Yes.
Sorry for troubling you, Millard, in the morning, Millard. Item number 11, Millard, I have come for this matter only, and today I have a return flight to Kolkata at 2:20, last flight. Now, Millard, since we will be doing it physically, this is an appeal against an order relating to Ponzi matter, Millard. And there is an order passed by the appeal court presided over by Justice Mukherjee, and to an extent we're given some protection. But Millard, we will be pressing for hearing of this, and last Monday we mentioned this matter, since they are not taken aback that this will be done, Millard, today. So we have given notice, Millard, and Lordship's desire was possibly this will be at the top. But however, Millard, I would only pray before my lords if this can be taken up, giving some priority, Millard.
Item number 11.
11, Millard. I've given notice to today also. I've given notice to.
The administration, I am there for private response with some other parties.
I am appearing for police authority.
I am appearing for one of the private.
Last time we had given notice that today we will be mentioning that also we have given notice.
I don't receive any notice.
Yes.
But today morning only this notice is
No, it's appearing in the list. Item number 11, probably.
that is appearing in the list. I'm sorry, I'm not appearing in this one.
Then last Monday it was there in the list. We give them notice that we will be doing it today. That notice everybody was aware of, subject to correction. Now, Lord, again we had given notice so that it can be preponed. That's it. So they know that it will be taken up today.
But my senior is not there. You are they are also aware about this. That my senior is not there.
Because I do not want to, maybe you do not want to make it part of. That will
No.
not serve the purpose.
No,
really.
no, Lord, certainly not. But we'll be praying for an interim order. In short, I tell your Lordship, just taking 2 minutes, Lord. Relating to a Ponzi matter, Justice Gangopadhyay assumed jurisdiction and passed an order. Our contention is orders without jurisdiction because Lordships knows, Lord, the Ponzi matter determination is with the division bench presided over by Justice I.P. Mukherjee. So if the order, Lord, passed without jurisdiction, that's a nullity that goes. Second point, the most important thing that I will be praying today, in effect, Justice Gangopadhyay will state the order of another coordinate bench, which he can't do with greatest of respect. And in effect, by effect of the stay, we can't proceed with the contempt matter. So, and the order of the division bench is very clear. For proceeding with the contempt petition, we have to obtain leave. The appeal may be heard out on some other day, but the contempt proceedings in effect can't be stayed because contempt, Lordships know, it's an independent proceeding. It's between the alleged contemnor and the
But
court.
the other side needs to be heard in this matter.
But we have given notice, this can't, and this is,
Leave is granted, that does not mean the content has to be heard, because there is a modern district judgment which says that court ordinary, when appeal is pending, the ordinary.
No, whatever needs to be considered on merits, even the stay application. And I have to hear the other side also.
but we have done our subject to correction. We have given notice all what they could have said that they will not be doing. Since I will be coming and doing it physically, that's why we have given them notice a week back, Today coming and saying that my senior is not there, think about my client, who had paid the expenditure. That's a practical thing.
Wait, please come back at 12 o'clock. I'll take the file and I'll
Absolutely.
see what is there in the
Just a short thing, and I will satisfy you, The judicial propriety says,
cannot be without hearing the other side.
No,
That is the impediment that
I know, they're here, whoever, the simple protection, simple interim protection I will be seeking, permit me to proceed with the content matter, which can't be stalled, That's the law. They can answer. They are not unrepresented. I will be coming at 12. I am grateful to you.
Can we answer this matter is a long history? There is a single bench, in single bench also there one matter relating to this.
please come back at 12 and take up the file. Let us see.
I am grateful to your lordship.
I'll read out the relevant portion, the operative portion. There is not an iota of evidence on record that suggests misconduct on the part of the petitioner. The statement of the victim is exonerative in nature and gives a clean chit to the petitioner. The decision of the authorities is based on no evidence at all, and no misconduct resulting in violation of the service rules has been substantiated against the petitioner. The authorities are referred to restraining the victim from copying in the examination by touching her shoulders from behind can under no stretch of imagination be termed as misconduct, more so since the victim herself has not termed such action to be inappropriate or malicious. For the said reason, the penalty imposed upon the petitioner is also utterly disproportionate and has no legal sanction. So we are inclined to hold that the decision taken and the subsequent decisions of the appellate authority and the tribunal, as also the inquiry report on the basis of which the orders were passed, suffer from the aforementioned laches and therefore cannot be sustained. The writ petition is allowed. The inquiry report and all the orders are set aside. The respondent authorities are directed to reinstate the petitioner in service with full back wages as well as other consequential benefits to which the petitioner is entitled.
Deeply obliged, Your Worship.
The petitioner is also entitled to cost of rupees 10,000 to be paid by the respondent authorities.
Deeply obliged.
On the last petition when Kelly was.
Which matter?
The one which is fixed for judgment. They said there is no vacancy available. On the 15th of October 2020, that is yesterday, they published their vacancy available. They say last one instruction, they submitted that there is no post available. But their own advertisement was provided yesterday in the Daily Telegraph. To indicate
That was not the only reason.
I understand.
That was not the only reason for their dismiss, their rejection. They have also said that the petitioner did not opt for the post. Yes. So you can come back in a review application because that's not the only reason. Yes. Yes, there is no bar in applying.
Unless there is an express order, they may say that since that we lost up to division bench, we will not, the fate will not know.
No, last time I had a line for this judgment shall not preclude the petition from applying before the authority afresh in case of future vacancy. You have to line last year. Pronounce for it. We just add a line that will not preclude you.
I'm good.
Okay, I'm reading out the operative portion. We have perused the entire case record, including the observation of the screening committee of several candidates. The candidates standing on the similar circumstances were also denied appointment on compassionate ground by the screening committee. And basically, the families in immediate economic districts were given appointment on compassionate ground. It further appears that the family of Vijay Lakshmi is getting family pension on enhanced rate, and they are living in their own house over the land owned by them. Thus, at this juncture, the observation of the screening committee appears to be justified. We find no reason to interfere with the observation of the learned state tribunal, state administrative tribunal. Accordingly, the instant WPCT is dismissed as devoid of merit.
We'll just add that line later. Cannot be.
It cannot.
Today it cannot be, but we'll. So that serves your purpose. No, return. Not necessary. Yes, next.
My lord, I am appearing for the petition.
If you could see, few minutes ago, I was given the file, so I have not gone through. Can it be day after tomorrow?
Yes, not today.
In the meantime, CD may be called. Case diary,
NDPS.
NDPS. ये शहीद जी, हाँ।
But since the matter pertains to Havelock here,
No, no, नहीं लाएंगे,
नहीं
शहीद जी.
in any case, I don't know whether day after tomorrow the CD will be available or not.
It will be available, only 2 hours journey.
The state is
It
the
is not-
best person to say so.
Let
The
it be on
state is the
Thursday, Your
best
Worship.
person.
Thursday.
Thursday, very good.
Cannabis plants.
Commercial quantity recovered from your possession?
No, no, no. Allegation is that the police recovered 2 cannabis plants from the land of some other person. I have been falsely implicated. The land is not my land. Nobody have seen that I have planted the cannabis plant.
90 kg or 90 grams.
Hmm, 90
Okay,
grams.
no, within that, not commercial.
Section 37 has been.
I have a
That has
copy.
to be seen. That
Okay.
has to be seen. That is to be seen.
He himself has filed this application under section 37 of NDPS.
That is
Page
the
9.
provision for bail. That is the provision for bail in NDPS case.
Let us see the possession.
37 is for commercial. Right.
Commercial quantity, yes. 37 is for commercial quantity.
Yes.
So in that case, he admits commercial quantity. On prayer of the prosecution, the matter is adjourned. Let the matter appear under the same heading on 19.
Thank you.
Okay.
Learned counsel for the state is requested to produce the CD on the agenda.
I'm for the, this is coming for admission under order 41. I have proposed the substantial question of law in the memo, my lord. Now, what has happened? A partition suit at the behest of the respondents herein were filed. The party claim comprised of 2 schedules. So far as schedule 2 is concerned, lordship, it is amenable to partition. But so far as schedule 1 is concerned, the land has been allotted independently by the government of Andaman Nicobar administration by issuing a license in favor of my deceased father. The trial court at the first round dismissed the suit. A first appeal was carried. But the district judge in the first regular appeal allowed the appeal of my client and remanded the suit for de novo consideration with the liberty to the trial court to frame additional issues on these issues, whether the license conferred to my father was issued by the administration or not. And on remand, the trial court framed the additional issue. On remand, the trial court, without assigning any reasoning, particularly with reference to the additional issues so framed, pursuant to the remand order, dismissed the suit. Approach was made to the first appellate court. Lord, the first appellate court decided something beyond the pleading. The first appellate court, which I challenge here, Lordship, held that in view of regulation 148 of local regulation, license could not have been issued. The Lord sees regulation 148 that has a different manner of application in a different context. Secondly, without there being a decree, without there being an adjudication by the trial court on my license, the first appellate court held license to be non-est, invalid. So, Lordship, I have come up with this appeal with this substantial question of law, which needs to be framed, Lordship. I'll just take to the trial court judgment and as also the first court's judgment. Lord, kindly turns to the judgment of the trial court. At I have not paginated, Lordship can find. There are 2 judgments. First is a first appellate court judgment, and second appellate court trial court judgment is dated 26 July 2026.
What were your prayers before the trial court?
Lord, I pray for dismissal of suit insofar as schedule 1 is concerned, because schedule 1 is a landed property
It
which
was
was,
independently granted. to the
yes,
trial.
Lord, license was proved as an exhibit. It was not considered by the trial court. Lord knows under the local regulation, the administration is vested with the power to grant license. That was done so. My name has been mutation. And the first appellate court says that I could not prove before the trial court the mode of acquisition of title. That was the title, Lord. Here in these island lordship, the ownership is vested with the government. The government, by issue of a license, conferred tenancy.
Right.
Ownership is conferred in that manner. Lord, would kindly find the trial court judgment once more, Lord.
Yes,
Lord, it is of 9-page judgment.
Yes,
My lord kindly turns to the internal page of the trial court judgment, more particularly while dealing with issue number 4, 5 and additional issue number 1 and 2.
page,
Page, no, I have not.
the internal page number?
It's internal page 6 of the trial court judgment.
Yes. You say that the property was granted to the father of the parties. Both the parties are
No, my lord.
brothers and sisters.
No, my lordship. The MM Shah was my grandfather.
Yes,
My father name is RK Shah. RK Shah is one of the son of MM Shah.
please come to page 6.
Page 6 of the,
Plaintiff numbers 1 and 2 are the daughters of MM Shah.
I am the defendant there.
And
The-
defendant number 1 is the son of MM Shah, and other defendants are also sons and daughters.
No, my lord, it's wrong finding. I am the son of RK
It
Shah.
is the submission, it's not the finding.
My lord,
Submission of the learned counsel for the plaintiff. Page 6,
my lord,
issue numbers 4 and 5.
just 1 second. It's wrong, my lord. This is what the wrong has been committed by the trial court. I've challenged this. This was recorded as if I have submitted it, but the record would reveal that I am the grandson of MM Shah. The defendant number 3, who is before this court in the second appeal, is the grandson. MM Shah's son's name is RK Shah, who is my father. RK Shah is conferred with the independent license in respect of the suit land.
Yes, so RK Shah's children are the parties to the suit.
No. RK Shah's wife and son are the parties. Defendant number 1 and 3.
And you are the daughter.
I am the son of RK Shah. M Shah is my grandfather.
Yes.
So I say, in respect of Schedule 2 property, the land was given to my grandfather.
Where is the plaintiff of the suit?
That has not been, it's a memo, my lord, not annexed it, my lord. I can bring it tomorrow, my lord.
The plaintiff has to.
Has to
there.
be seen, my lord. And moreover, my lord, secondly,
Because if what is recorded is correct, then they also have a right to.
Absolutely,
To
but
the property.
absolutely, my lord, absolutely. But there is one more point. My mother died during the pendency of the appeal, first appeal, before hearing of the appeal could take place. But the judgment was passed in a dead man file. It's the other substantial question
Was
because
it brought to the notice of the court?
it's on ignorance, it was not, Lord. It was not, no, but there are orders of this court admitting this appeal, second appeal on this ground. If rightly or wrongly the death is not intimated, because under the law of
Please
Lord,
show me the orders.
I'll place it. I'll place it.
Please show me.
I'll bring the plaint as well as the orders on this line.
Tomorrow?
Tomorrow.
Not-
Tomorrow.
The wife of Lady Long. Wife of. Hmm.
The number 1 son of MM Shah.
Even Shazam for evidence. MM Shah's sons are also defendants in the suit.
Yes, yes, my lord. So far as Schedule 2 is concerned, it is amenable to partition. But so far as Schedule 1, 1430, 1431 correspond to the land which
If
has,
the property was given to MM Shah,
yes,
license was granted in favor of MM Shah. MM Shah's sons are also.
no,
defendants.
license in respect of Schedule 1 was not given. It is in respect of Schedule 2 in Hafrigan property.
License in respect of Schedule 1 was given to MM Shah.
No, it is only Khasra register based on which the entire finding goes. Khasra register under the local regulation is nothing but a FMB, field measurement book. It neither creates title nor excludes title. It is a license granted by the authority in terms of regulation 146 confer valid title under the regulation, Your Lordship. The trial court as well as the first appellate court.
So that license cannot be inherited, you say? That license cannot be inherited by the legal heirs?
No, license in the name of my father. So the moment my father dies, the property schedule 1 has to be devolved upon me being the son and my wife, my mother who is no more. My husband's
The license was in favor of your father, not
Arkesha.
grandfather.
No, Arkesha, yes, in the favor of my father, Arkesha, Ramakrishna Shah.
Please come back to the
The
relevant.
plaint
documents.
as those orders.
Yes,
my lord.
yes. Will you come back tomorrow?
Tomorrow, sir. Tomorrow, sir.
A learned counsel for the appellants seeks to produce certain documents. Paragraph, let the matter appear under the same heading on 17th.
No blame.
I'm appearing for the appellant. But in terms of the court's order, I have to submit the calculation part, my lord. It has been vetted, it seems, my lord. Through proper senate has not been received to me. I just pay for a day's accommodation, my lord, so that the stay application can be taken care of.
The day after,
Yes, ma'am. No blame.
on prayer of the appellant, the matter is adjourned. Paragraph, let the matter appear under the same heading on 18th.
No blame. Able for the statement.
The informant, being my daughter-in-law, was staying all through in Andaman Nicobar Island. Before leaving this island, she has intimated the concerned police agency that she's leaving this island to stay with her parents' house, and she will not claim anything as against me, as against my son. Now, she had been to West Bengal. She lodged a complaint relating to the allegations which pertains to Andaman Nicobar Island. Lord, an FIR has been chalked out there. Lord, I have come up with this application for transfer because
You are the mother-in-law.
I'm the mother-in-law. But the allegation, Lord, would see FIR page 11. The alleged place of occurrence is South Andaman Port Blair. The allegation is at South Andaman Port Blair.
Have you served the de facto complainant?
I can say,
Since it's a transfer application,
my lord,
she needs to be heard.
my lord, my lord.
And the report was called for.
My lord, I received copies of the case diaries through email. And it reveals, my lord, that the case is pending investigation.
Right.
It is yet to be finally reported. Unless it is finally reported, the transfer of case does not arise. The question of that does not arise, my lord.
Not only that, a notice needs to be served upon the de facto complainant
My lord,
also,
my lord.
because her
My lord.
convenience is required to
my
be
lord.
looked into.
Yes.
Please.
So please serve and the next.
Since she has not been arraigned, I may be granted liberty. to-
Yes, you have.
My lord,
Since it's a transfer.
my lord, I understand.
A report submitted on behalf of the state is taken on record. Paragraph. On prayer of the petitioner, comma, liberty is granted to implead the de facto complainant. She is Deboshri Das.
Yes,
Deboshri Das as respondent number 3 in the application. Paragraph. The petitioner is directed to serve copy of the application along with annexure thereto upon the added respondent and file affidavit of service on the adjourned date. Paragraph, the matter be placed before the next available circuit bench.
no blame.
I appear for the statement.
This appeal was there last week. Your lordship had fixed it for hearing on and from today.
Yes. This is that 106 matter.
Madam,
Can you complete today?
I will probably not be able to complete today, but if your lordship can take up after the second half also, I will stay on.
We have our single bench matters, lot of matters are pending.
This will take some time.
Because I'll suggest that we do not start in that case because we have just 3 more days with us.
Madam, if I can conclude by tomorrow, then my learned friend can address your lordship on
Then-
Wednesday.
Shall we write the judgment after that? Isn't it?
Why-
That's a practical difficulty. We are 1 day short in this circuit.
That
Yes.
was my lord,
That's
might
the
maybe
reason I
shifted
had
to
asked your
next
lordship
circuit.
to.
Yes,
Maybe shifted to next circuit conveniently.
these, I don't know, these very complicated, lengthy matters.
This was why I had asked your lordship for permission to start it last week.
Yes, but learned council was not there. I couldn't have done, we couldn't have done that. It's quickly.
There are a total of 30 witnesses, which I will have to place,
So how,
and the evidence is there to be read.
in fact, I should say, I should very candidly say that this should be very difficult in every circuit.
Has to be done
So
sooner or
don't
later,
you
Madam,
have,
because this person is in custody.
Don't you have the provision of asking for special leave before the chief justice?
We cannot do that until and unless the circuit is not here. If the circuit is not here, this matter can be transferred there to be taken up by the bench having determination there. But the problem is, in that case, we have to shift my learned friend and myself also to Calcutta to do the matter. This is not the sort of case that can be
Since
done
it
over
was the
briefing.
submission that it needs an elaborate hearing, an
Madam,
extensive hearing. Let's see what you can do.
Madam, that is why this has to be done on the first day of a circuit. If we can start this matter, then it will be completed.
So next circuit, please inform learned council so that you can start on the first day itself.
The
Otherwise,
matter
it will be
is-
difficult.
the matter is in the list every circuit, madam. I don't need to give a separate notice. The state
No,
took
only
time.
abundant precautions, so the learned
I
council is ready, that's all.
I understand, madam.
We all know that it is running in the
I
list.
understand this. Anyway, it doesn't help anyone to make these submissions. So
Yes, absolutely. Learned counsel for the appellant submits that the appellant is in custody and the matter shall require a lengthy and extensive hearing. Paragraph. Since this circuit, since only 3 working days remain in the present circuit, comma, the matter be placed before the next available circuit bench.
would it be your lordship's pleasure to consider a bail application?
No, because the nature of the, because it was earlier rejected.
True,
Yes.
it was earlier rejected on the submission of the state that the appeal would be expeditiously.
Immediately after the vacation, so come. I pay for the state your lordship.
Directed us to produce the marriage certificate, not we have filed it.
You said that during pendency of the appeal, they are married.
Yes, yes. Not prior to that,
Where is the marriage certificate?
it has been filed, my lord.
And this is not in dispute that they are married.
Yes, my lord, they have a child also.
It is also an admitted position that the girl had an affair with the accused.
Yeah, the cross-examination, what has been done, your lordship, that is what is troubling.
What is the cross examination?
Can you kindly come?
And I do not find any document which says that the girl is below 18.
That is my submission.
Just a minute, I'll come to
And
that.
the girl herself says that.
She's 18
she is
years,
18.
160%.
She herself says whether any document Is there or not, we have to.
But page number 39 is the 164 statement, my lord.
Give me a minute, please.
Yes, madam.
Page number
39, my lord.
of the paper book.
Yes, madam.
And what is the cross-examination that is troubling the state?
Your lordship may kindly come. She says that she doesn't know. PW1. No, PW1, definitely.
Now, ऐसे कुछ नहीं. Now, Mitu. Now, Sabri.
PW
PW1,
at page.
page 2.
Yes.
Yes, Your lordship, I think I'm mistaken. She was turned hostile. One sentence why I say your lordship, that is point 7. I cannot say the father's name of Mukesh. Actually, he is held responsible for my pregnancy.
She may not be knowing Mukesh's father's name.
He is held responsible.
And
for
admittedly, Mukesh is responsible for the pregnancy because they were in a love affair.
love affairs.
And she has said it is done with consent.
Yes, madam.
So,
Now, her age we have to look into.
yes.
What documents they have placed, the prosecution has placed to do the age.
And the girl was referred to the police station by the hospital.
It always happens because section 21. Everybody who comes to know about any sexual assault upon a minor has to inform.
Upon a minor.
Upon a
How
minor.
did the hospital ascertain that she's a
That we
minor?
have to look
But the
into it.
doctor himself certified that when she has come at the time, she was 17 years, 9 months the pregnancy. But rather the prosecution has produced 2 documents, my lord, which is at page number
Page number
52 and 53.
52.
If my lord will see page number 53, the documents which they say that the admission form and the father himself has given an undertaking that he will produce the birth certificate. But rather that birth certificate never come on record. Neither
This
has
is
been
admissible.
seized.
This is admissible.
No, my
and,
lord, it is not admissible.
In Juvenile Justice Act. Admission form of the school is admissible. If we go by 15/6/2005, what was her age at the time of pregnancy, we have to look into.
If
So when
that
she was
thing,
pregnant, that was on 27/10/2020. So she was pregnant at that time for about 23 weeks. So in 2020, what was her age? We have to calculate. 2005. Okay. 16. She was minor. below the age of 18 years, 16 plus. So consent doesn't matter. Where the matter?
She says 18. Where is the document? The
She
father
says
really-
18, but the admission form of the school has been duly exhibited.
But that admission form next page may be seen, my lord, if the father himself has given undertaking. It is also assured that I will produce birth certificate to my daughters as early as possible. And that no birth certificate ever been produced.
Has any
Based on the verbal submissions, the forms have been filled up.
no cross-examination to the
But
effect
I
that
understand
she is
that
a
cannot be-
minor or a major, no cross-examination to that effect. Ought to have given a cross-examination to that effect that she is not a minor, she is a major.
My lord, if that being so, the prosecution has already had all the instrumentality to ascertain the ossification test of the victim so that the
Ossification
correct
test
age can be
be-
found on record. That has not been done. And moreover, the second aspect, the doctor at page number 40, the doctor said that he informed that the is pregnant at the age of 17 years and 9 months.
Where
Page
is
number
that?
40, my lord, page number 40.
So that also shows that she is below 18 years. Consent doesn't matter.
But that doesn't matter, madam. The Honorable Court has adjudicated that issue, not with regard to below 17 years. Then the question comes, not if above 17 years, when living in as a relationship, and the victim himself had said that he was in a relationship with the in 164. And moreover, the Honorable Court has framed a charge. That is page number 1. The main charge was that below the whether the victim was below the age of 18 years old. But rather when the judgment comes, the Honorable Court presumed that it was 15 years, so he has convicted here. He neither touched the document of page number 40. The doctor's opinion neither no, I understand, Lord, the cross examination more than the trial from that cannot be because it is an appeal. But subject to my lord's kind consideration, Lord, we kind of they are living within a family as an husband or there is no minor child. And the Honorable Court at the time of adjudication was admitting the appeal based on the 164 as well as the documents which is produced by the 40 consider the bill and director produced the marriage certificate. We have produced it. Not, if at all he is an habitual offender, if he has been willfully or on an information of
Bail was considered earlier in this
Yes,
petition.
yes, yes.
In this appeal, where is it?
It's been considered. Based on the 164, the bail was granted.
এটা স্টার্ট করার জন্য
কিছু করতে হবে না, please সামনে কথা বলবেন।
My lord. Am I audible, my lord?
Sir, probably live streaming has been paused. I
My
don't
lord,
know.
am I audible? I'm in serial number 12.
My lord, I am in serial number 11.
I'm so sorry. So sorry. Extremely sorry.
No, actually, the entire system has been paused. I do not know why it has been paused. So we are not in a position to know the position of the Port Blair bench. Yeah.
This is that public interest litigation whereby the sitting of tribunal with regard to the Central Administrative Tribunal, they are agreeable for 5 circuit. And my lord, I have said that in terms of their own undertaking.
You are asking for 6.
6, and in terms of their own undertaking at clause 2.3 and 2.7, whereby they say that one judicial member is yet to join. Once he joins, we will
Yes, Mr. Shivaganam?
My lord, I'll be seeking,
Instruction on this?
my instruction from Calcutta CAT is that to seek extension of time.
no, no, this is what going on from. My lord, what I'm not being traveling beyond anything. I am saying,
I'm not really suffering, Mr. Kumar.
no, I am not suffering, but the thing is.
Video conferencing
My
is
lord.
going on.
My lord.
Having 5 circuits,
My
we
lord.
are asking for 6.
My
My
lord.
So
lord,
since they're asking for extension to
My lord.
decide once and for all, isn't
My
it?
lord, my lord.
That will be better, right?
My lord, like that an order, my lord, that they are seeking
it has to
time.
be conveyed from National Administrative Tribunal and DOPT has to be consulted. My lord.
So let them take time.
Let them file a supplement. My lord.
Decision.
My lord,
Please impress upon your client.
my lord.
A learned counsel for the respondents seeks extension of time to take instructions as called for. Paragraph, the matter be placed before the next available circuit bench.
Much obliged, my lord.
Well, yes, so just call once. If they are, all the parties are there, then
Good. 11 to.
yes, is everyone there? The administration has some difficulty.
My lord, in item number 11, I am appearing.
And it's like thousands of investors have invested in this company and so that's my lord.
their interests are also involved. That's why that I. Because the Pratul Chakravarti to be here because he is from the beginning in this matter, mother. It's like a Sharada over here in the.
No, it's not that. I will tell you, Lordship. Just give me 5 minutes in a nutshell, my lord. I will tell you, Lordship, the facts, my lord, and what I am bringing for your Lordship today. My lord, may I tell your Lordship the facts? Property, my lord.
But who are the respondents who are appearing?
My lord, I am appearing on behalf of, my lord, I am appearing on behalf of respondent number 1, 2, and 3
Yes.
from Calcutta, my lord. Because before my learned friend starts, my lord, if my learned friend give me some opportunity, actually this is an application, this appeal is relating to a cheat fund company.
Yes.
And I am appearing on behalf of the depositors, the unfortunate depositors. My lord, I am only pressing before your lordship that in the paper book in 186, page number 186.
You are submitting on merits.
Yeah, very well, very well.
Has to have the first right of audience.
Very well, very well.
And I would like to ensure that all the other respondents are there. Otherwise, I cannot take up the.
All are present, my lord. All have been served twice, my lord. When
1, 2, and 3. You
I'm
are,
appearing.
yes. What about 4, 5? Administration, you are there. The rest is all administration.
9, 10, I am appearing.
9, 10.
11, 12 also you must be appearing. Mr. Chakravarti should be appearing. What about 13?
Rufus, my lord,
Rufus?
I am the appellant before you.
Infra project.
No, this is infra project. 13
This
is
is
a
infra project. How can appellant and the respondent can be the same person, my lord, if it is?
separate entity.
13.
Who is appearing for 13?
My lord, 13, my lord. 13, my lord, and 12, and the appellant before your lordship. 12 and 13 before the trial court. Yeah, my lord. Same entity almost. Entity is different, but the allegation is same. And appeal has been preferred by
How
one.
can you represent the appellant
No, I am
and the
not. I am
respondent?
not. I am not. But if you see the writ petition, my lord, what you could find, the identical allegation has been made against two group companies.
Maybe, but where is the service upon 13?
13 years, sir. 13 never appeared, I am told, before the
Where
trial.
is the service, sir?
Trial court also the
So
name.
when it's an appeal, you have to serve.
Two, my lord. Kindly have a look at my lord once, my lord.
Where is the service? So 13 has not been served, I guess.
My lord, kindly, my lord, sees, my lord, once the order, I am told, my lord, Mrs. Nag was appearing before, my lord.
Mrs. Nag has withdrawn on the.
Yes,
on
that's
the
true.
earlier service.
That's true, my lord.
So after that, there should be a fresh service.
Not necessarily because they know, my lord, that the appeal has been prepared and they were served and requested to come. We may change the advocate, my lord. I think, my lord, subject to what falls from the court, my lord, it has been served.
No, Ms. Nag was appearing for the petitioner.
Yes, I am also,
Yes,
I am the appellant, I am the respondent number 1.
but
Mrs.
not responding to the 13. Ms. Nag was not appearing for 13.
Mrs. Nag was. Mrs.
She was not appearing for
Mrs. Nag was appearing, my lord, for the appellant, the respondent number
So
11.
the appellant and 13 are different entities.
And that's true.
So please show me the service on 13 before I start.
Kindly, my lord, if lordship sees, my lord, or give me the copy, my lord, my junior says, my lord, it has been served. my lord.
This is the copy. This was given to us just now.
I'm sorry, my lord. Yeah.
One to 12.
Check the record. You want to see the record? Only record record there and question your service.
There is no other affidavit of service on record.
Without service, direction can't be done, so there was a service.
That may have been missed out also. I want to see the service, because this becomes a ground for a, I mean, it's
I tell you,
difficult.
Lordship, absolutely, Lordship is absolutely correct, Milord. What my learned junior says, Milord, without service, Milord, possibly there could not have been any direction for filing the paper. In any event, though there are two entities, the allegation is same, and one Mrs. Sounds, Milord, is control of the two companies. Appeal prepared by the roofers, and the other roofers was made the pro forma respondent. Both were not served, and in their absence, Milord, an order was passed in the writ petition. So one came up before the appellate court, the other chose not to. And the order,
If they do not appear despite service, I can take up the matter. Rather, we can take up the matter, but you have to show me service. Before that, I cannot.
I know, Milord, but if there was a previous direction prior to, Milord, just once, Milord, seize the order, Milord.
There was a direction for paper books, but it
Milord,
doesn't say.
kindly, Milord, have a look at the order passed on 3rd of April. It's not part of the paper book. When, Milord, this was moved before.
Yes, 3rd of April.
Lordship will see, Milord, kindly have a look at this order.
There also, there is no representation of 13, I'm afraid.
Yes, they didn't appear. That's the reason we didn't serve separately.
Didn't appear is one thing, and not serving is another thing
Absolutely,
altogether.
Absolutely.
A very short issue is being.
No, I understand.
stretched.
I
So,
understand, but
If you have a service, please show me. If you do not, please serve and come back.
No, Milord, I don't think it has been served.
Please
Milord.
serve and come back, sir. Please serve. I cannot take up a matter like this.
He can appear virtually as well. It's not that he cannot appear virtually.
No, that I understand.
Learned counsel wants to appear physically, so
No,
that's
it's
his
because
choice.
of, it's
Absolutely.
because of client's desire, to be very honest.
And that's his prerogative.
definitely.
The court cannot.
An appeal matter, sometimes, Milord, the connectivity issues is there, Milord, sometimes it gets disconnected. These issues are there, and
I
client's
know.
prerogative after all.
And it's always better to hear it out at a stretch.
Certainly, Milord.
Otherwise,
No, Milord, my prayer would be very limited. I don't, Lordship is absolutely
I've
correct.
seen the liberty also granted to you, but that cannot be done. I've just had a cursory glance of the record, but then that cannot be done in absence. Just serve 39 now. It's bad luck.
Then, Milord, may I say this, subject to what falls from the court, Milord, kindly, Milord, fix a date at the earliest and direct me to serve, Milord, the respondent number, Milord.
The next date is next circuit because we have 3 more days.
No, that's true. I can't force the court to take up an appeal matter. Only, Milord, some indulgence may be given so that it can appear at the barely at the top, Milord,
It
before the
will
next.
appear, and please,
And pass an order directing me to serve. Because
Hello?
they
Hello?
chose not to appear, and probably any order from,
please see that this appears on the first day of the next circuit, right? Please ensure.
and kindly, Milord, pass an order to serve the formal order I will serve.
Yes, because it's not served at all. Since service upon the 13th respondent is not complete, comma, the matter be placed before the next available circuit bench. Please serve and come.
No,
I'm really sorry.
No. But Milord, the thing is,
Come out of the way.
they have, Milord, same stand.
Since they are not pro forma, they are principal respondents in your application, in your appeal.
Milord, the trial
You
court,
could have made them pro forma respondent if the stand was the same.
Milord, I have to give the same cause title what was given in the trial court. And trial court also,
So
Milord, the important thing, we were not even served. Nobody. And they have their same stand, and if Lordship sees the allegation made in the writ petition, it's identical allegations against the two. They come up with the story of Ponzi. Now, Milord, my grievance is that writ petition, Milord, by which, Milord, a direction was given to the Tahsildar to remove the encumbrance, that has to be heard. That has got no way connected with the Ponzi matter. In any event, the Ponzi matters relates to the determination of the division bill. However, assuming that there is a good case of Ponzi, Milord, I have defrauded the respondent. But the content matter arising out of a writ petition has got no way connected to that order. And in the writ petition, Milord, no challenge has been made. So order remains final and binding. Now, what the single judge did, Milord, he said the effect cannot be given to that order.
We have made that submission already.
Absolutely. How that can be done?
If they do
If
not,
my learned friend wants to make any submission with regard to the merit of the matter, my lord, I'll draw your lordship.
comment because we cannot take up the matter like this.
Very well, very well. Then it is all right. Then my learned friend should not make any comment on the merit of the matter.
I have done. I have done. Next,
I'm grateful.
May I please, your lordships? May I please, your lordships?
Madam, this
May I
matter
please, your lordships?
station and there are several private parties as well. So what has been fallen to me, my lord, 3 of the private parties are appearing, although 2 are not appearing, and all union is also a party. I don't know whether the union is served or not, because there is a new paper book has been filed, my lord, in this matter.
Your lordships, my advocate on record is there. Probably he'll be able to clarify if he's served upon every respondent, because that was the instruction.
Record in this matter? Yes, have you served all the respondents? Where is the service?
Union of India.
Please show me the service. Who is it? You're appearing for the private respondents?
One of the private respondents.
Where is the service on Union of India? Please show me. Union of India, 972. Mr. Lal represents Union of India, isn't it? So why don't you serve a copy to him? Yes,
Served upon us, we were assigned to work through the branch secretary of Calcutta. If it is served on us.
service has been made at Delhi.
We are assigned.
So what is the procedure? You get the instructions from Delhi?
We get the instruction from the law ministry, stand secretary to Calcutta.
So till date, you have no instructions in
No,
this matter?
no.
And what about the private respondents? 357.
One other advocate was also there on the morning
Dipankar
for
Majumdar.
some other private respondent.
Where is the service upon all the private respondents? It's all item received, it's not served.
So, lots of.
Item received doesn't mean item served.
Delivered hai kya?
It has to be,
Everybody is here, you know.
yes. The affidavit of service that you have given just now, it shows item received.
Lots of, there are two
It should be
affidavits,
item delivered.
there are two affidavit of service.
One is here, where's the other affidavit of service? It dates back or 25/7, which one? This also shows item dispatched. Last item dispatched. Okay, refuse, that is also delivery. Shall we wait for the Union of India, because one of the private respondents is represented?
Yes, your lordships.
Some are served, some not. And the Union of India has not received instructions as yet.
In that case, your lordships, in the interest of justice, probably another time would be fair to be given to them to come with instruction.
What is the matter about?
Yes, your lordships. The petitioner was he was appointed back in 2009, but he was terminated after 4 years of service without any show cause notice. But your lordship, something prevailed in between. That is, soon after their appointment, on the basis of written test as well as personality test, some people were appointed. And one unsuccessful candidate challenged this particular appointment before the learned tribunal. Learned tribunal saying that the appointment, the selection on the basis of appointment was not there in the advertisement. Now, the learned tribunal allowed the order, allowed the application, saying that yes, re-advertisement of posts would be there. This was challenged by us, Your Lordships. The Honorable High Court, in that case, said that setting aside the order of re-advertisement, the Honorable High Court said that selection process will start from the stage, will continue after the stage of, from after the stage of written test. This was challenged again in the Supreme Court. Supreme Court affirmed the decision of the Honorable High Court. Now, and thereafter, the appointment has been made, wherein this petitioner was, this petitioner's name was not there. Now, therefore, we challenged again before the Honorable Tribunal. Honorable Tribunal found out that no, there was no infirmity in the reappointment, because the selection was made on the basis of the written test only. Now we challenge this order before this Honorable Court, saying that the order of reappointment, order of fresh appointment of the petitioners is inextricably linked to the order of termination of this petitioner also, which was without any show cause notice, without any blemish found on his part. And that was definitely an error on law. And these two orders are inextricably linked. Now, our cases, Your Lordships, though the order was that yes, the selection was to proceed from the stage after the written test, it was never, it is our case that the Honorable High Court mentioned in its order, in the last order, that relying on the judgment of Ashok, page number 93 and 94 of the paper book, Your Lordships, if kindly has a look at, relied on the judgment of Ashok versus State of Karnataka. There, Your Lordships, this Honorable Court declared in the order, observed in the order, that this particular judgment is applicable, wherein it was stated that 15% of marks for personality test could be allowed, and that could be this case would be applicable in this case. And Your Lordships, there are further judgments also, which Your Lordships are aware that personality test, especially that is a criterion that cannot the power of the power to see to select the best. The personality test cannot be ruled out, and there is no provision that yes, it is only, the advertisement did not say that it will be only on the basis of written test and nothing specific, and just because nothing was specifically mentioned about the personality test, our humble submission is that it could not be ruled out. And Your Lordships, the respondents in their submission, page 204, Your Lordships would find that while making the decision, the page 204 of their of the counter of the paper book, Your Lordships, they said that interview was personal interview was considered at the aspect of the candidate must have a good physique, attitude, ability, and good health to perform the duties of chainman, process server, and peon. So this was considered, and it was never the case that this power with the authority would be ruled out at any point of time. Another aspect of the matter is, Your Lordships, after all, the main case started with an unsuccessful candidate who took the personality test with the knowledge that yes, that was there, and because it was well publicized also, it was not a surprise personality test. And subsequent cases, Your Lordships, the cases of Karunesh versus State of Karnataka, and Tajveer Singh, Your Lordships, which these two cases we have enclosed with the paper book. They say that yes, unsuccessful candidate cannot question this election process. This is the law, Your Lordships, which is our humble submission before Your Lordships.
Let the union be
Our petition.
Let the union be represented, because they are still not represented. He needs to take instructions. Let him come back.
Please, Your Lordships.
The Union of India is not represented. Paragraph, Mr. Lal, who usually represents the Union of India, submits that he has not received instructions in this matter till date. Paragraph, the matter be placed before the next available circuit bench. Let him come back with instructions, madam.
Most obliged, your lordships.
I'm there for the. As Mr. Tango on the last, he said I can start with the matter because we'll be running on issue on arresting. The issue is very different. But the petitioner hearing was a police matter at constant. But he enforced a government revenue bank. Now using this term, this government revenue and for the sole reason, because in these islands.
Who is appearing from Union of India? You are appearing.
Yes, sorry, the government, but I still, the instruction is.
Local administration are the main parties here.
I am told that there is no further shot against me.
Nothing really has been sought against me.
So shall we continue?
Well, but the government revenue land is an encroacher or it's a person is a squatter of a government revenue land. He or she can establish his site in his, it's a lot. Yeah, suppose Andaman is concerned. Upon enforcement of government revenue land, I find this. It is still pending, a status quo order has been. But the employer, my employer, if he initiated a disciplinary proceeding, a charge sheet has been issued against him, saying that the land which I am possessing, it's police land, so they have contemplated disciplinary proceeding, charge sheet was submitted. But this is, it's the round of application. So every stage of disciplinary proceeding, I have challenged the action of the authority before the trial. Order will pass, I approach this court, the matter is going to time. Ultimately, Lord, by order in June, the tribunal held that my act of encroaching the land tantamount to misconduct, and I have been dismissed from the service because the disciplinary authority as well as the appellate authority have dismissed me from the service. This is the point which I have raised before. I'm laying on two grounds. Whether my act of encroaching a government revenue land, the amount of misconduct, and the punishment is disproportionate. It's not a misconduct. What kindly turns to the impugned order.
You have been terminated.
I have been dismissed from the service. And now a criminal case was initiated at the behest of police agency, and I've been acquitted also.
Yes, let us go through the documents one by one.
The impugned order is at page 277. The pagination ends up in us. There are two paginations. Pagination within the circle that needs to be seen. You want to find this is the order of the learned tribunal. And this I'll take belongs to the include finding of the learned tribunal, where not my original application was rejected. What I have arguing now, Lord, this was argued before the learned tribunal, and they have formulated my argument at page 278. The tribunal have formulated the points which are placed before the tribunal.
Yes.
Well, they have placed it's 2.1.
Yes.
At the outset, it is required to mention that this is the third round of litigation, three factors are as follows. That while the applicant was working as constable, FS 170 posted at police line, he was served with various notice dated 18/2/2018, 8/9/2008, 24/8/2010, whereby he was informed that he has encroached upon the keys of police line situated at Bahadur line, F1 Nayagaon, South Point, and was directed to dismantle this semi-house, Pakka house constructed by him on the sector. Since the applicant did not vacate the enclosed police department land and he did not adhere to the direction within the notices, treating the said act of the applicant as great misconduct or indiscipline, and the disciplinary proceeding was contemplated against the applicant of the Chief of Police, Andaman and Nicobar Island, respondent number 2, report hearing, placed applicant along with others under suspension while order dated 21/9/2010 in exercise of power conferred by Rule 9.31 of Andaman and Nicobar Office Manual 1960. The applicant filed a title suit number 48 of 2011 before the Court of Civil Justice for a decree for declaring the possessory right, title, and interest of the painting for the suit land, as well as a decree for permanent injunction restraining the defendants, their servants not to disturb the peaceful possession of the applicant over the dwelling house along two clearing fields in an area of 200 square meters in survey number 3 of the one situated at Parkour line, Nayagaon village under Portland, district of South Number. In the meantime, the respondent number 4 had issued a charge memorandum dated 21/2/2011 against the applicant under Rule 9.3 of Andaman and Nicobar Police Manual 1960 for the alleged act of encroachment of applicant on government land and the same amounts to grave misconduct and indiscipline under Rule 8.85, 8.86, and 8.87 of the Andaman and Nicobar Police Manual 1960. Along with the said charge memorandum, the applicant was also served with the articles of charges, statement of imputation of misconduct, list of documents, and list of. At this stage, it is also important to mention that the applicant, along with the titles that file an application of the petition under Order 39, Rule 1 and 2 of injunction against the defendants, including the respondent number 4. After hearing London lawyers for the original defendant number 4, as well as the respondent number 4 hearing, as also the London City Council for the other defendants, the London Joint Civil Judge Senior Division allowed the petition of the application of the applicant under Order 39, Rule 1 and 2 of CPC, and the parties were directed to maintain status quo for the suit plan till disposal or until further order. The said order, injunction order was passed by the Competent Civil Court on 25/3/2011 and actually was corrected. Thereafter, in response to the charges memorandum issued by the respondent, the applicant had submitted his representation dated 15/10/2011 and requested the disciplinary authority to stay the departmental inquiry in the light of the injunction order number 12 dated 25/3/2011 passed by the London Civil Judge Senior Division Blair in title suit number 48 of 2011. Said representation of the applicant was rejected by the respondent via memorandum dated 9/11/2011 on the ground that the departmental proceeding and the matter pending before the London Civil Court are entirely different. The applicant being agreed with the charge memorandum dated 21/2/2011 and opposed this tribunal by way of filing way number 195 of 2010. The said way was dismissed by this tribunal video order dated 27/4/2012. Against the said order of the tribunal, the applicant filed a petition before the Hon'ble High Court and Calcutta, Indian Application number 495 of 2012, which was disposed of on 17/7/2012 with the liberty to the petitioner to assume the order of dismissal before the tribunal, and all the issues raised were kept open for agitation in the subsequent proceeding, if any. Meanwhile, with the order dated 14/7/2012, a major punishment of dismissal was imposed upon the applicant. Challenging the said order of the punishment, the applicant once again approached the Hon'ble High Court at Calcutta by way of OA number 140 AM of 2012, which was decided by order dated 5/12/2012, with the observation that the said OA was premature as the applicant has not exhausted all the statutory remedies available to him under the rules before approaching the tribunal. Operative portion of the said order dated 5/12/2012 is refused. This has been the opinion that the present way is premature applicant is required to exhaust all statutory remedies available to him under rules ordered accordingly. The applicant had filed a petition number WPCP number 187 of 2012 before the Hon'ble High Court and Calcutta. Said petition was dismissed by order dated 18/12/2012. With that opportunity with the petition to file a statutory appeal within the fortnight from the date of said order, and the respondents were directed to dispose of the same within a reasonable period by meeting an opportunity of custom hearing to the applicant. As the copy of the said order was received by the applicant monthly on 41/2012, he filed a CAN application number 6 of 2017 with WPCP number 72 of 7/2012 for extension of 1 week to file appeal. The said application was allowed on 17/1/2013. Thereafter, the applicant had filed a statutory appeal dated 4/2/2013 to the appellate authority against the order of dismissal dated 14/7/2012. The statutory appeal dated 4/2/2013 filed with the applicant against the order passed by the disciplinary authority came to be rejected by the appellate authority video book number 1398 dated 26/2/2013. Being agreed with such rejection, the applicant approached this tribunal by filing OA number 95 of the A of the 13, the said claim was dismissed by this tribunal by order dated 7/10/2015 with following orders. Thereafter 2.10, the orders were referred to the person of the tribunal. The applicant had approached the Hon'ble High Court at Calcutta challenging the approached order value of filing number 349 of 2015, mainly on the ground that he did not get opportunity to submit or argue his case, and in his absence, the case was dismissed. The Hon'ble High Court by order dated 18/11/2015 dispose of the petition that is WPC number 349 of the 2015 with the following orders. The petition says that the petition could not be recommended for the reason beyond the control of the petition, and the petition will apply for review of the tribunal's order, including wherein WPC number is particular to be without going to merits thereof, and by leaving the petition to approach the tribunal, if we deal with the matter in a constant. In view of the above direction by the Hon'ble High Court, the applicant has filed a review application in number 22 before this tribunal for recalling of the order dated 11/10/2023. The RA was disposed of on 9/11/2021 with an order to this OA for hearing in the next level. Parties were also directed to exchange their return of the parliament. Accordingly, the letter was again finally heard. The learned counsel for the parties and the learned counsel for the applicant paying his submission. But the points which are submitted has been noted down, right from 3.1, same point. Several paragraphs repeated, which I have argued just now, and thereafter, now page 286, they kindly see from paragraph. This is what the respondent has calculated for the learned time. I will tell you. The respondents have filed a written reply denying the claim of the applicant. The post submission of the learned counsel for the respondents are as follows. After inspecting the land in question, Inspector Housing PhD has submitted a report on 6/2008, whereby it was reported that the police personnel, including CS Arulappan, FS, the applicant hearing, therefore, a notice was issued to the applicant along with others to remove and vacate the illegal enforcement within 7 days with a letter dated 18/2008. In response to the said notice, the applicant hearing submitted an application dated 29/2008 requesting to allow government extension of water, and he had assured the police department that after adoption of warrant, government order to vacate the unauthorized encroachment on police land. In reply to the said request of the applicant, delayed police letter dated 8/9/2008, the respondent directed him to vacate the unauthorized encroachment within 15 days, and further he was informed that the state for adoption of government order would be considered as per. It is submitted that despite issuance of notice, the applicant did not vacate the police land which was imposed upon him. A letter was sent to the Tahsildar Kotar on 8/May/2000 for physical inspection of illegal encroachment on the land allotted to Andaman Nicobar Police Department situated at Shadipur, Bahadur Line, Roman 1 and the Tahsildar Kotar, a letter dated 24/8/2009, has submitted a report after physical verification that as per revenue reports of Nayagaon, the land bearing survey number 4/27/1, 2/1, 30/1, 31/1, 32/1, and 5 adjoining areas respectively situated at Nayagaon are recorded in the revenue department in the name of police department. In the said report, the Tahsildar has confirmed that the applicant here is enforced upon police and machinery in area 212. It is averred by the respondents that since the applicant and other 14 persons found as encroaching on the government land were repeatedly asked to vacate the land and they did not vacate the said land, in spite of various police issues to them, the respondents placed them under suspension in view of contemplation of civil proceeding against the applicant and others for gross misconduct and violation of mandatory provisions of Rule 8.45, 8.46, and 8.47 of Andaman and Nicobar Police Manual 1960. It is submitted by the respondents that except the applicant as well as another police person, namely R. Nagan, all other police persons had negated their enforcement from government, and therefore said police persons were reinstated in the service except the applicant and not the R. Nagan. Since the applicant and Sri Nagan are Nagan did not take any heed to maintain their illegal enforcement, a common disciplinary proceeding was initiated against them within the memorandum numbers also dated 21/2/2011. Just after issuance of the said order, Reserve Inspector Police Line had created a report on the same date, that is 21/2/2011, stating that Sri R. Nagan, follower sleeper of the 151 had negated the unauthorized occupation in view of the said report. He was reinstated in service. It is submitted that the applicant himself had admitted that he had included in the stand. presided of the applicant in amount to gross misconduct being a member of a district court and as such said act of the applicant is in violation of rule 8.45, 8.46 and 8.47 of Andaman and Nicobar Police Manual. The challenge to the initiation of disciplinary proceeding by filing an OA at the initial stage, the OA was dismissed by the family. Private counsel could argue that the Andaman Nicobar Police Manual 1960 was notified under section 7 and of Police Act 1860 and promulgated by the Honorable President and the service of the applicant being police staff was governed by the provision of said act. Therefore, the contention of the applicant that the rules of the said manual do not impose a law is unreasonable and the same is required to be checked. The learned counsel argued that it is a certain principle of law that even during the pendency of criminal proceeding against the context of the disciplinary proceeding simultaneously. Therefore, the contention of the applicant that the yes, before the civil court, the disciplinary authority ought not to have initiated disciplinary proceedings simultaneously is not valid. It is stated in the present case that the applicant has admitted that it enforced upon land allotted to the police department, not only that the land in dispute was in fact allotted to the police department by the authority. Further, he submits that even if the land is from the government or not a government, no government servant in present in the police personnel that is applicant can impose upon any government act. Any such act of the police personnel amounts to grave misconduct in terms of its service condition included in the police manual. It is submitted that the departmental inquiry was conducted against the applicant by following the principle of maximum justice. All relied upon documents supplied to the applicant. The CEO, that is applicant, has submitted his defense during the inquiry. On conclusion of the inquiry, it has submitted this inquiry report dated 6/6/2012, wherein on the validation of the evidence during the inquiry, it said, "IU recorded this conclusion to the effect that the applicant was still occupying the enclosed land, police land, unauthorizedly and constructed a semi-pakka house without any permission, being a member of discipline court, which amounts to great misconduct and indiscipline for which he was liable for punishment under Rule 9.5 of the police manual." Further, it is stated that a copy of this report of inquiry officer was supplied to charge officer by the disciplinary authority to submit a written defense within 15 days and had also offered him custody. In response to his SUVRA had submitted a written defense without promoting for custody. After considering the entire document, the inquiry, the report of the inquiry officer as well as the written defense, note of the applicant on the said report of the disciplinary authority by agreeing with the findings of the inquiry officer held that he did not find any denial of natural justice to seal during the course of departmental inquiry, concluded that the charges leveled against the applicant stand free. By observing that the protector of law turned into injustice cannot be tolerated, standing and taking into consideration all aspects of the case, the case imposed penalty of dismissal from Andaman and Nicobar Police Service upon applicants immediate effect for this even grave act of misconduct delayed order dated 14/7/2012. Therefore, the learned counsel for the respondent vehemently submits that the disciplinary proceeding was concluded by following the principle of natural justice and based on which evidence produced within the inquiry, the DA passed the order of punishment under Rule 9.2 of Police Manual, which is just and proper. Further, it submit that the applicant was also considered by 88 and by assigning the proven event applied order passed by DA. Therefore, in absence of any procedural lapses in the inquiry and disciplinary proceeding, the applicant can respond entitled for any aspect of the third and the conflict of insight can produce the taking on board. It emerges record that while the applicant was working as police FS, he was served with the charge memorandum under the provisions of Rule 9.0 of Andaman and Nicobar Police Manual 1960. According to learned counsel for the applicant, since rules prescribed under the Andaman and Nicobar Police Manual has no force of law, and the disciplinary proceeding instituted against the applicant under the policy of the said manual, the same is required to be enforced. Number one, learned counsel for the respondent categorically submitted that Andaman and Nicobar Police Manual 1963 was modified under section 7 and 12 of the Police Act 1961 and promulgated by the Hon'ble He submits that the service of applicant being police staff of the respondents was governed by the principles of Andaman and Nicobar Police Manual. it is apt to mention that applicant is not in a position to contradict or rebut submission of the rendered copy for the respondent by way of any reason and not has produced any material contrary reply to the respondent. Therefore, in our considered view, the submission of the applicant that the disciplinary proceeding was initiated and the applicant has no force of law is not anything. Thus, we are in agreement with the learning submission and learning respondent that the service of applicant in the police staff of respondent was governed by the principles of command and police. It is noted that the disciplinary authority has issued charge memorandum dated 21/2011 against the applicant to hold an inquiry under Rule 9 of the Environment Police Manual 1960 for the alleged misconduct of improvement upon policing and situated at Barulai Police and had constructed a semi-patla house on the said land illegally without permission or knowledge of the authority. And in spite of notice, they had served to clear the enforcement that the applicant had not correctly. The said and on the part of the applicant was treated as grave misconduct and indiscipline in terms of Rule 8.45, 8.06, 8.9 of Andaman and Nicobar Police Manual 1960. Along with the charge memorandum, charge sheet stated 21/2011, the applicant was served with the statement of articles and charges, statement of imputation of misconduct, list of documents and misconduct. On receipt of their charges from the applicant and not submitted any. However, after inquiry was ordered to conduct department inquiry against the applicant on basis of memo by the said inquiry officer dated 3/9/2011, directing the CO to appear to hold preliminary inquiry the applicant can submitted his investigation and 2010-2011 before the disciplinary authority requesting the state authority to state in the department inquiry on the ground that before issuance of charge memorandum, the complaint was lodged by the police department with the state officer area order under the Public Police Act against the applicant for this eviction from the land. He was served with the notice of the land and was paid on this. Meanwhile, he filed a title suit to say this and this family shelter from construction of the new land being case 48 of October. After dealing all the parties, the letters report passed an order of injunction dated 25/3/2011 directing for responsible case to maintain status quo over the suit land. According to the applicant, since the allegation in the charges memorandum and subject matter of challenge in license filed by the police identical in nature and an order of maintain status quo of part of its report, he requested the DA that is proceeding in the department inquiry may be state to discuss. It is noticed that the said representation of the applicant was rejected by DA while order dated 9/11/2011 on the ground of partnership proceeding and the matter pending before the governor civil courts are entirely different. Accordingly, the applicant was directed to coordinate with the department and inquiry proceeding. Further, it also emerges from the record that the applicant had assailed the legality and validity of the charge memorandum dated 21/2011, A number 195 of the KN of the before this tribunal, while dismissing the said OA white order dated 27/4/2012, consider the submission of CO that is applicant hearing that since he had approached the civil court for declaration of concessionary right over the land which he alleged to have imposed upon the applicant and under the circumstances, the alleged enforcement of applicant on the land cannot be treated as misconduct. Therefore, the respondents were not justified to initiate disciplinary proceedings. It is important to mention that while answering the questions whether enforcement of land allotted to police department made by the applicant in police person belonging to disciplinary force in misconduct or not, this tribunal, by referring the law laid down by the effects to in the case of Union of India versus reported in 1979, and state of Punjab was ex-constable Ram Singh 1994 had observed that the justification advanced for justifying an act of enforcement by the applicant and undisputedly the applicant did not dispute that he is in possession of land which has been allotted to the police department. Further, the applicant had given undertaking before the respondent to the effect that he would clear this encroachment during that. That encroachment of land by him is not an excuse, and accordingly the OA. At this stage, it is pertinent to mention that being agreed with the order passed by this tribunal in OA number 194, the the applicant had approached the Hon'ble High Court at Calcutta by filing the number 495 of 2012 during the pendency of the revision on conclusion of departmental proceedings. The disciplinary authority delayed on the order dated 14/7/2012 by agreeing with the report of inquiry authority held that the charges level against the applicant had. The said interpretations came to be dismissed as the infractions by order dated 17/7/2012 by granting liberty to the applicant to assail the order of dismissal before instruction. At the same time, the Hon'ble High Court had clarified the cost imposed by upon the petitioner by this tribunal related to order to be set. As noted here above, challenge to the order passed by the disciplinary authority ended 47/22 in the present. When the counsel for the applicant mainly argued that the disciplinary authority as well as the appellate authority passed the review order solely based on the which was prepared and submitted by the consular to the effect that the applicant and other police personnel are. According to learned counsel for the applicant, till date, the competent civil court had not approved the said report of enforcement submitted by the consular. Therefore, the finding recorded by the PA and upheld by the AAA are not enabled, and the same is required to be passed and succeed. The learned counsel reiterates that since the interim order passed by the civil court to maintain status quo on the disputed land is enforced, the respondents ought not to have proceeded with the disciplinary proceeding against the applicant. As against the learned counsel for the respondents vehemently submit the charges leveled against the applicant was related to the enforcement on police land. The applicant himself had admitted that the land on which he had constructed a semi-pakka house was not allotted to him, nor he owned the said land. Therefore, issue pending before the civil court is a different than the charges leveled and the issue involved in the disciplinary proceeding instituted against the applicant. It is a settled principle of law that the court will not act as an appellate court or and gives the evidence that in the domestic inquiry, not interference on the ground that under this possible on the court. If the inquiry has been fairly and properly held, and the findings are based on evidence, the question of adequacy of evidence or reliable nature of the evidence will not be a ground for investigating the findings. Refer the judgment in the theory of economic and Debbie versus Nations and Nagaya. Further, the Hon'ble Appeals Court in the case of state of Karnataka and another versus N. Gangaraj reported in 2020. Held that tribunal High Court shall not go into the discrepancy between the evidence. Once the evidence can be accepted by the department in excess of our of the initial issue, the tribunal or the High Court will not interfere with the finding that recorded by the as if the court starts in appellate court. It is also appropriate to refer the judgment passed in three judge Ravin Kumar versus Dina Punya and others reported in 2029 at 64.7 months, wherein it was again said that the evaluation of position making position and not in merits of the in the background of the victim laid down by the school and in view of the facts it is evident that the order passed by the disciplinary authority as well as the appellate authority the charges level against the applicant to the effect that he had illegally encroached upon the police land near police quarters situated at Babu land and had constructed semi-pakka house on the said land without any permission from knowledge of the applicant and others were placed under suspension by the disciplinary authority. Further, it is also alleged that 10 police personnel were reinstated after they dismantled the semi-pakka house and vacated their them. But address 170 gets available despite of several notices and legal instructions of the competent body did not pay any heed and bother to vacate this enforced land. Being member of police force act on the part of charge officer must to bring misconduct and in discipline and the said act of the CEO within contravention of mandatory provisions of 8.45, 8.06 and 8.47 of Andaman and Nicobar rendering the CEO unbecoming of a member of ununiformed police force and making him liable for punishment under Rule 9.2 of said act. In the present case, as stated above, undisputedly the applicant has admitted that he had encroached upon a police land and on the said land constructed a semi-pakka house. In other words, he has admitted the charges level against him. However, these demands of the applicant that since he has opposed the civil court of protection of his
These are repetitions.
it's ultimately must be tribunal held. I'll just come to that. Straight away to page 298.
Yes.
Yes. 98 to 99, not the original application of distinction. Not the limited attached to the order that. Not whether my act of encroaching the land, which is in fact not a police land, I'll from not to be my plane. They say 31 of the 1 to be the police, assuming for the sake of argument. So I go by my plane process, plane, if not to see the plane, it has nothing to do with 31 of the 1. The scheduled landed property is 3 of the 1. Coincidentally, also that land is within the same village. This is one aspect. So I was given with a quarter. There is no dispute. Just far away from my quarter, there is a government land level. I have occupied it. But I have been put pressure to vacate the quarter. My letter, which I have submitted, do not relates back to the suit land, 3/1, but that relates to the quarter in question which I have vacated. They have taken this letter to hold against me. My first point is not. This would not amount to misconduct. The judgments.
The quarters was in police land.
Yes, yes. There's no dispute with it. And that is what.
That is 31/1.
30/1 point. So kindly have look to the material which are placed before the tribunal, more particularly plain. I'll just show the copy of the plain. I'm owed 3/1, which has nothing to do with the 31/1 law. So kindly turns to page 82 of the paper. 80 instead of 84. I'll take straight away to page 84, which is the schedule of the property involved in this. It's a
This is 3/1.
3/1. Same village, Bahadur line. And one of the trial court, considering the material on record at page 88, protected my possession for a limited period till disposal of the suit, this man not find at page 91. And suit is as of now.
Has the trial court prima facie recorded that it's government land?
Just I'll come to that. Yes. The prima facie. Yes, Lord, kindly comes to page 90, last but one paragraph. The prima facie consideration. Satisfaction recorded by the civil case. Last but one paragraph, after going to the case of the respective parties, admittedly it appears that the plaintiffs are in possession over the suit land, the scheduled land. They are residing in the suit land by constructing a house thereon, and it is an admitted position of law that no one can be evicted without due process. As per the submission, based on this and based on the other material, what would be at page 91, simply direction to make
Status quo.
as regards my position. But this was taken in a different way by the disciplinary authority, and the order of dismissal by the disciplinary authority was endorsed by the appellate authority. Copy paste not true. Words were borrowed by the appellate authority. There is total non-application.
As well as by the tribunal.
As well as by the judge. As well as by the judge. Hold on. There's one more thing I'll just show. Please, they may argue, Lord, a criminal case was initiated at the behest of police first against me. A case of criminal trespass was lost. So I have been acquitted there. Even the criminal court has held that I'm not in a police land. So kindly see that judgment. It starts at page 268 within this article.
Yes.
Same facts which not find from the facts evident from the disciplinary authority. My act of encroaching police land, my act of criminal trespass, ultimately the criminal court at page 276 not acquitted me from this case, and this judgment has attained its finality.
But here it's survey number 30/1, not 31/1.
Even not this criminal court said that I'm not in a criminal trespass. That's not, it was the first situation the criminal court recorded the case of the police agency based on which the GR case was initiated, that I am over the police land. Even the court said, criminal court said that I am not in a police land. 2012, I have been dismissed. But the punishment, I'll just refer to the police manual and the judgments which were considered by the tribunal. Those judgments, the police personnel got found roaming in the bazaar with gun, service gun, in an aberrated condition. This was the facts. But here the facts is distinguishable on. Here I have simply enforced my land. Not water part is concerned, I have surrendered it. But revenue itself, but these things need to be hashed out in a suit. And prima facie, I am enjoying an impression. The criminal court has given a clean sheet to me, saying that you are not in the position. There's a criminal found.
Please indicate the initial orders.
Yes, yes, of the court. Because at every stage, the proceeding is challenged. Now I'll just show the first order of this court. The impugned memorandum is at page 97. But at that threshold, a challenge was made that you cannot sustain these charges against me. Not, and I filed challenging this memorandum at page 97 by filing an original application, and which was dismissed. I'll just show that. Page 115 came to be passed not. I have challenged page 115 in a original application. I'll just show that. At page 110, the tribunal held that since challenge was to a memorandum, you cannot assail my limited ground to argue at that material point of time during 2012 with regard to memorandum of charges for one. I was inspired with the judgment of the ethics court saying that on the such same and identical facts, the disciplinary proceedings should not proceed. The cat had nothing doing, rejected. I approached this court at page 119. Because page 115, the first order of the tribunal. Yes, I'll show that. Or to see page 110, tribunal while dismissing my original application at page 114 imposed cost of 10,000. Page 114 of the paper.
Yes.
That was yes, order was challenged at page 119 of the paper book. The rest part of the order was maintained and the cost was not imposed. The reason for passing order at page 119 is lordship. By the time my writ petition could be taken up, they have passed the final order dismissing me from the service. So I sought liberty from this court. Since a fresh cause of action has arisen in my favor, liberty be granted. The court granted the liberty at the same time, and then the cost part. Then again, my lord, at page 122, approach was made. Then, Lord, the tribunal said, again dismissed it at page 125, saying that the order of dismissal ought to have been appealed against under the service rule.
That is at page 125.
126 is this second order of this court. This court held and dismissed my application, saying you go before the appellate forum under the service rule, challenging the dismissal order of the disciplinary authority. I approached thereafter. I just show that. Then, Lord, page 134 is the appeal before the appellate authority. 134.
Yes.
Appellate authority simply endorse the finding of the disciplinary authority at page 156. Page 156 is the order of the appellate forum following the order of the disciplinary authority, thereby I will dismiss. These two orders not get challenged before the tribunal. I'll just show. At page 214. Page 214 was passed in my application, thereby challenge was referred to these two orders. Parent order of the disciplinary authority and the order of affirmation. But on this day, that is on 14 July 2012, I was not represented. So my original application was dismissed. Then I approached at page 218 again before this court. This court, not
218.
218.
Yes.
Page 225 में kindly किसी को note, order dated 18 December 2021. Order of the tribunal was challenged. Then not page 231. Because he was granted to file appeal because before there is not to be order that the direct process. Then not to page 232. It's an appeal being taken off by my client before the appellate forum under the service rule. And then what this page at 255 of the appellate forum came to the power 26 February 2030. Page 255. 255.
Yes.
Then Lord, again those two orders, tribunal was approached at page 259. Page 259. In OA number 95 of the AN of the 2030. And this application was taken when the counsel for the petitioner could not remain present and it was dismissed. But I approached this court. This court said that you need to approach the same court by filing a review application. I filed a review and review was allowed and the matter was taken up on record and the order is in date. This is that. So I'll just show the manual. And that is I don't have the light. And I will show that undertaking lordship upon which the tribunal is totally spread away. Saying lordship that I have even undertaking to vacate the land in this. I'll show that also. So as this rule 845, I'll just show this of the police manual.
Eight- 8.45.
May I read 44? I have, but I'll get the photos because it's one, it's old one. May I read the photos?
Do we have it?
Says, Police manual 1963.
Only one cup?
I'm sorry, no, I can get the photos.
We have one copy, we'll share. 8.4.
Yeah.
Once.
Eight point four get paid, but I can find it with 60.
Yes. 8.45.
4, 5.
Yes.
Integrity of the highest order is in the fundamental basis of prestige of police. Recognizing this, the police must keep their private rights, develop self-restraint and be truthful and honest in thought and deed, in both personal and official life, so that the public may regard them as exemplary citizens. 8.45. 8.46, the police should recognize that they can enhance their utility to the administration and the county only by maintaining a high standard of discipline and stinted obedience to the superiors and loyalty to the force and keeping themselves in a state of constant alertness and preparedness. So 8.47, no police officers are in any place and whether on leave or on duty, conduct themselves in any manner or take part in any activities calculated or likely to bring the force into contempt or to be prejudicial to the maintenance of good order and discipline of the force, or to be prejudicial to the proper performance of duties of the force. Lord reads between the line of this 8.45, 46, and 47. Lord, this has applicability in different contexts. Or what I have to, Lord, besides working as a police person, I have my personal life. I have encountered, as I said, in this island, there are schemes being promulgated by the administration time to time. But even a squatter have certain recognized right under the local regulation, that's 66 regulation. I can establish my right. If my not supposed to regulation 2028 of 1966, well, I'll just place that regulation. Even an encroacher, can assert his or her right over the land, provided I fulfill the sine qua non. Now 202 may kindly be seen of this regulation, local regulation. 202 of this regulation.
Yes,
Penalty for unauthorized occupation of land is under the chapter.
yes, yes.
So any person who takes or remain in possession of any unoccupied land or abadi may be summarily ejected by order of Tahsildar, and any crop which may standing on the land and any building or other work which he may have constructed thereon, is not removed by him within such time as the Tahsildar may be, shall liability to. I'll take brought to straight away to subclause 7 at page 41. No order made under subsection 1 shall prevent any person from establishing his right in a civil court. If notice of an intention to institute a suit is delivered to the Tahsildar, he shall desist from carrying out his order under subsection 1 for a period of 3 months, and if such suit is filed within such period, he shall stay his proceeding pending the decision of his civil court. Under this regulation, one can, rather an encroacher can establish his or her right in a civil suit. I do not dispute whether I am a squatter in respect of a different land. 3/1, for which a suit is filed. Suit is pending. Based on such facts, the police says that I am in a police land. They approach the police authority by initiating a FIR. Even the police court said, no, you are not in the police land. This is criminal trespass. What else is required? This thing was missed by both disciplinary authority as well as by the appellate court. And not the judgment, if the tribunal has relied, I just one judgment. If the tribunal has relied to discard my claim by rejecting my original application, I just say that judgment is not. This, in the case of this State Bank of Calcutta and Jaipur, which the tribunal has discussed and it's at page 295 of the Indian judgment. So there was a misappropriation of money. This was the allegation. And the judgments are distinguishable in fact because none of the judgments which were relied by the respondents, which the tribunal considered, decides the identity. None of the case deals with any matter that the applicant in that case was encroaching a land, its was pending, status quo was granted, respect of some other land, they were punished. So these judgments could not come to the aid of the respondent.
This is this Praveen Kumar's judgment. Praveen Kumar versus Union of India.
One is crossed at page 9295 of the paper book at the last line, where the tribunal has referred to this examining statement, State Bank of Bikaner and Jaipur versus Nenichand Nalbaya,
Page 92.
295. Who told not that the court cannot reappreciate the evidence. The allegations was something else and was under different context.
Yes.
I'll place this document, you know. Judgment is an authority on the point which is deciding what. Ratio of deciding I can understand. But now some applicability of the law has to be there. In order to make application of a judgment, the slightest difference in a fact. Now, slightest difference in a fact makes the authority knowing difference. There no the facts are totally different. But the other judgment which the tribunal has relied, that it's a state of Punjab and other versus, it is shown. Ram Singh, in the case of 1992, volume 4, SEC page 52.
Relied upon by the tribunal.
By the tribunal at page 294. This was on the fact, not just I'll just case that paragraph, please. So the police person in that case was charged that he was found in an inebriated condition and he was wearing the police dress with service revolver. This was the allegation. There the court took stringent action that no, this has to be done, this has to be condemned. The dismissal is perfectly all right. But that was not the case before the tribunal, the present case is concerned. From here, refer was to the disciplinary authorities initial of dismissal. That page. One four of the paper book.
That's the ex parte order.
I'm saying also the dismissal punishment is disproportionate. The material also because before the tribunal because this to the interference of the orders of the dismissal.
That's all your submission. Yes. Yes, the Union of India. Submission of the state, right? What about the state?
Not to, but to. Whether it is the police land or the land, the revenue land. Encroachment of government land tantamounts to the commission of offence. Therefore, assuming it is not related, that he is in other plot and not in this plot, thereby he will be getting some relief. No, he has committed an offence. Even by encroaching another plot, being in the disciplinary service.
Which is government land according to the appellant.
Yes, revenue land, he is stating that.
Revenue land says yes.
The moment he encroaches, the police person said to have committed the crime. This is what we do. And section 447 speaks about there are certain ingredients which may not be attractive.
The criminal case has been
Why not the criminal? The requirement of section 447 by trespassing the position whether the occupier has been annoyed or not. This is what perhaps we require.
So these ingredients may not be attracted, therefore that acquittal may not confer any title or legitimacy of the petition.
And what about regulation 202, which allows the trespasser to file a civil suit claiming his right?
That be there, my lord. The question is, the first question is section 4. Whoever commits encroachment commits an offense. Now the decision lies with the government. How to behave with that? Well,
So the government
assuming it is not in this plot or that plot.
and the trial court cannot decide?
My lord,
The trial court cannot decide?
my lord, you never do. It's a different matter, my lord. Altogether different matter.
Trial court. will
Trial court
require
demands
evidence.
the title of the property encroached upon. But the right to have the service in the disciplinary department, it is two different.
But here, in this subject to whatever Mr. Chakrabarti will state down Wednesday, what I have understood, I am submitting on that. But here he himself has accepted, admitted that he is on the police land.
No, he's on.
In the judgment, if Cat judgment, your lordship will see, he himself on several points, Learned Cat has stated that, and he has not disputed that.
Where is the admission?
But
You cannot.
one thing more, my lord, that there is 3 proceedings: civil proceeding, criminal proceeding, and one is public premises tenancies proceeding. Now, public premises tenancy in page number 293, they have served a notice under Public Premises Tenancy Act. But that notice has to be challenged either by way of section 5 of PP Act or section 7 before the district judge. That is not been challenged.
Where is the?
Kindly see page number 293. From the top, before issue of the charge memorandum, a complaint was lodged by the police department with the state officer ADM.
293, the rounded to.
Rounded 293, my lord.
Yes.
And the internal page 7 of the order. But before
Yes,
the issuance of the charge memorandum, a complaint was lodged before the police department with the state officer ADM under the Public Premises Act against the applicant for his eviction for the land in dispute. He was served with notice for vacating the disputed land and was placed under suspension. So this notice has never been challenged by him.
After that, title suit was filed.
Title suit was filed. But the thing is that even Supreme Court from time to time and recent judgments are passed that the disciplinary proceeding is separate and the civil proceeding is completely a separate proceeding.
Supreme Court has said disciplinary proceeding is different from criminal
proceeding,
not civil. Proceeding.
There are judgment we say that civil proceeding also does not affect the disciplinary proceeding.
Please show me the.
There are, I'll definitely, I'll try to find out, madam. So, the disciplinary proceeding, in this case, I don't think that it should be interfered with because, from time to time, he has granted opportunities of hearing, ample opportunities of hearing. The CAT, there are 3 to 4 times of appeal and petitions before CAT and High Court. However, the CAT has come to final conclusion with a recording of ample reasons that why, and giving opportunity to both the parties, recording of reasons which are not arbitrary in nature. So, I don't think that this honorable court can only interfere with due respect with the decision of the tribunal or subordinate post when there is the lack of reason, where there is the arbitrariness or something.
Even if it is beyond law.
Beyond law.
Beholds the law itself.
Beholds the law itself. But this is not beyond the law, my lord. So this your lordship has to look to whether this is beyond the law or not.
That's all.
That's all, my lord. Now
Continue on
let me
Wednesday.
continue on Wednesday because nothing to say. You have stated the case judgment entirely.
Yes, yes. For learned counsels for the parties. Paragraph, learned counsel for the administration seeks accommodation. Paragraph, that the matter appear under the same heading on 18.
My item number 1, may I just mention one thing? May I pray for my removal of the cost of 10,000 because the reason is that this and that entire person, that item number 1, the POXO, where the POXO procedure is the teacher was.
You have to file a review, and in a review, you cannot ask for removal.
I'm just praying. Can a date be fixed within such time we have to reinstate him and to pay the cost or something?
I have not-
Otherwise, they will come against with contempt application in some time only. It will take otherwise some time, my lord. The date
I have
is
not stated a date, do it as early as possible.
my lord. Grateful.
Well, let it be listed. We hardly have time. Yes, call the list, please. Respondents, Mr. Lal is appearing.
No, Manoj, this is, we are the respondents, but we don't have the copy of the writ petition. We have asked the department to supply us the copy of the writ petition. Madam.
There is an order of the Honorable Supreme Court.
And thereafter, on the last circuit.
It was mentioned.
The other matters, the same issue, the order has been passed, that order has.
But
Already passed. Wherein,
but the respondents,
in that matter, responding to similar.
no, in this matter, I found Mr. Lal was responding.
Correct, okay. The first order is different. Yeah, identical matter has been disposed of in the last. That order.
Please show me.
Here with regard to stamp duty, it has to be paid as per the old stamp duty or the new notification. That has to be decided. The division bench has already decided the matter. The administration has preferred the appeal for the Supreme Court. That has been decided. Thereafter, the last decided. My issue is also the same, within time prior to the notification, given I have applied for, submitted
The application for registration was prior to the notification. And the notification has a post-dated effect. Yes, Mr. Lal, what is your submission on this? Next circuit. There are several pending matters. I don't think we can take it up again. But have you gone through this order?
What has happened yesterday, department has shown our name. However, sir is appearing, they're stepping aside, but I also don't have the copyright, no, sir also don't have the copyright. So this is the problem.
But they need to see the file, isn't it? They have not seen the file at all. Let it appear day after tomorrow if it is possible. On prayer of the respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 18.
Item 2, WPA 878 of 2021.
My lord, I am appearing for the private respondent.
My lord, I am appearing for the official respondent. I seek extension of time to file opposition, my lord.
I am also.
Who is
seeking
appearing for
to-
the petitioner?
Mr. Jaipal.
Where is Mr. Jabbar?
I am also praying for extension of time. This is first extension.
None appears for the petitioner. Paragraph, the respondents seek extension of time to use the affidavit in opposition as called for. Paragraph, the matter be placed before the next available circuit bench.
Obliged.
Obliged, my lord.
Item 3, WPA 893 of 2020.
I will
filed our affidavit in opposition.
My lord, I have received the opposition
Today only
today.
have served.
So I will reply, use my reply. 2 weeks
Seven-
time, maybe 2 weeks time.
2 weeks time.
Yes.
Learned counsel for the petitioner seeks a fortnight's time to use an affidavit in reply. Stop, the matter be placed before the next available circuit bench.
Obliged.
Item 4, WPA 917 of 2023.
Well, in this matter, I appeal for the petitioner. I am appealing for the result. My lord, in this case, what happened, my lord, the copy to the respondent was not served by me.
Copy was not served.
Not served by me to the respondent. And
Mr. Kumar did not. receive the copy.
he got the copy.
The authorities served.
Authority served.
Yes.
It was incomplete, my lord, during the course of, I have come across that it is incomplete. Some documents were yet to file, that's why I did not serve. The department, without informing me, they served it, I know, it came to know through Mr. Venu only.
So that's an incomplete copy that.
My lord, some documents are to be filed by supplementary affidavit. At page, some of it.
Are you ready with the supplementary affidavit?
My lord, permission is to be short for my lord, then it is.
Very well, I grant you, let me come back with the supplementary affidavit.
My lord.
On prayer of the petitioners, comma, liberty is granted to use a supplementary affidavit annexing relevant documents. Paragraph, the matter be placed before the next available circuit bench.
My lord.
WPA 926 of 2023.
Lordship, item number 5 and 10 are identical matter. I am
Yes.
for the petitioner, your lordship.
And for the bank respondent, my lord, I seek extension of time to file opposition.
As
Affidavits were called for.
Yes, my lord.
and I
First
was, and
extension,
the
my lord.
last occasion, there was a direction to serve upon the private respondent again. I have
Have you
did,
served?
I have. अभी अलग नहीं डाल कृष्णा अलग डाल अभी डाल डाल In the meantime, I will file the affidavit of service, your lordship.
You are not ready with the affidavit today?
Lordship, no, your lordship.
Great. Learned,
Earlier, the writ petition was served.
the
Director-
affidavit of service showing service upon the private respondents is not ready. Paragraph. There was no direction for affidavits.
My lord, there was a direction, AO by 2, affidavit opposition by 2 weeks on 26 September. Maybe in another case, connected case.
Item number 5 and 10 are identical
Not
matter.
in this way. You want to come back with an affidavit in
My
this
lord,
matter also?
yes, my lord, same matter.
Paragraph,
Same,
the
identical
counsel for the official respondents seeks to use an affidavit in opposition in this matter. Paragraph, affidavit in opposition be filed within 2 weeks,
My lord,
within 2 weeks from date. Paragraph, affidavit in reply, comma, if any, comma, be filed within a week thereafter. Paragraph, the matter will be placed before the next available circuit bench.
Right, my lord.
Item number 10 because.
Same,
it's the
same.
issue.
Identical.
Item number 10.
Yes, your lord.
Item number 10, WPA 942.
I am for the petitioner.
I appear for official respondent number 1 and 2.
Here also there is no direction. Let
My lord.
the same order be passed.
Obey, your lordship.
Obliged, my lord.
Item 6, WPA 928 of 2023. My lord,
I appear for respondent, my lord.
my senior is appearing in this matter, madam. He is held up before court number 2. This not to do, madam. The matter get.
Matters cannot be made not today any further, sir. There are several matters fixed to in the last 3 days. What is the matter about?
Regularization of land, my lord, it needs to be of Mayabandar Tehsil.
There's a direction for affidavits.
I seek extension of time, my lord.
Already the extension of time has been extended.
Since it's Mayabandar, I could not get the instruction, my lord. I pray for extension of time.
Learned counsel for the respondents seeks extension of time to use the affidavit in opposition as called for. Paragraph, the matter be placed before the next available circuit bench.
Oblige, my lord.
7, 8, 9 also.
Same, my lord. 7, 8, 9,
7, WP 930 of 2020.
I'll just call one by one.
my lord.
Yes, same order.
WP 931 of 2020.
Same, my lord.
Same.
Same order. The issues are also the same in all these.
My lord. Same is.
9 WP 934 of 2020.
Same order.
Okay.
Highly oblige, my lord.
Level, SAT 1 of 2023.
My lord, I am appearing for the appellant, my lord. Division bench has framed the substantial question of law.
So it will go before the single bench now.
No, my lord is holding single bench.
Yes? Oh, I'm so sorry. I'm so sorry.
So, my lord, the direction is to be given for registering.
paper.
Yes, ma'am.
The appeal has been admitted upon formulation of substantial questions of law. Paragraph. Lower court records be called for. Issue usual notices. Paragraph. Paper books be prepared within 4 weeks. Should be sufficient, within 4 weeks after receipt of lower court records. Paragraph. The matter be placed before the next available circuit bench.
Well,
Item 30. WP 105 of 2020.
Well, we have filed our affidavit because on last occasion, this matter was, Mr. Jaipal was also there. The question was whether the report and thereafter the order was based upon the report or was not. Their submission was the surveys was not conducted in presence of the tenant. Whereas our submission was the order was
And
passed
what
in presence
produced
of the-
documents.
We have produced the document through way of affidavit. Affidavit is filed. I am serving the affidavit upon my learned counsel.
The affidavit. What does your affidavit say?
I just say that the order was based upon the report only. It's not-
Was
nothing
notice,
before.
yeah,
Some of the tenant was,
today they are filing it. Have you're filing it today? The affidavit?
we have filed that previous week, my lord, but I've served it today only upon the others.
Is it on record? Your affidavit?
Should be on record. I think they have.
Because
made
on the last
mention-
date, there was a direction.
My lord.
So when did you file after that?
On Friday or I think on Friday they have filed.
Yes, please, please. Yes, any document to show that you served notice, the survey was in presence of the petitioners?
The survey was maybe not, but the order was passed in present of the petition, which is after the survey.
What is challenged is the survey.
The survey was challenged on previous in 2020 date. However, the order was again challenged in 2021 date, and the same thing was said, my lord. So the order subserves the
This is
survey.
the 2020 writ.
2020, and thereafter 2021, it was also filed. With same party.
We are dealing with the 2020 writ, not the 2021 writ.
But the learner senior submission was because thereafter the order was passed, my lord, on present of both the parties. So now this report merges with the order, my lord. But this matter can be fixed on Wednesday as well. They will also get a chance to go through this, my lord.
How many matters are on Wednesday and how will orders be passed? Wednesday? You are fixing all matters on Wednesday. Because this time we are a day short, isn't it?
My lord.
Come back on Wednesday, let's see. And your affidavit is also not on record.
My last question. Many a times happens that when you do it through a way of notary, my lord, it takes time, my lord.
Affidavit in opposition is yet to be filed. Paragraph, learned counsel for the petitioners who has received a copy of the said affidavit seeks to take instructions in this regard. Paragraph, let the matter appear under the same heading on 18.
Item 19, application 74 of 2021.
My lord, in this matter, my lord, on the other day, my learned friend was arguing. Now, in this matter, my lord, I find that I have not used my reply, my lord.
Oh, to the opposition.
Yes, my lord.
A week? 1 week?
1 week, my lord.
Hey, anyhow, the next argument will come. So,
No, at least the exchanges should be ready.
my lord.
Oh, one reply is there. Sorry. One reply is there, my lord, but my record also, an original reply is there. I have not affirmed it.
How is that possible?
Maybe, my lord.
Do you want to come back with the further reply?
My lord, let it be in the next circuit, because on the other day, my learned friend relied upon an OM that is not part of their pleadings in their
They
opposition.
want to produce.
Yes. So that is not part of the affidavit in opposition, my lord. So let it be in the next circuit, my lord, and I will.
On your prayer,
Yes, my lord, on my prayer.
on prayer of the petitioners, the matter be placed before the next available circuit bench.
Item 20, WPA 9 of 2018.
My lord, in this matter, argument was concluded by both the sides. Only I have to place one judgment to my lords, my lord. This is that matter where the municipal authority promoted a person on ad hoc basis on the basis of the resolution adopted by the Port Blair Municipal Council, my lord.
Yes.
Only I am relying upon one judgment, my lord. I have said that it is of a single bench, my lord. But the issue was same, my lord. I will just place the relevant portion. If my lord comes to page number 2, second paragraph.
Yes.
It says, my lord, it appears that taking a sympathetic view of the situation, a meeting was held by the PBMC on August 5th, 2013. At the said meeting, it was pointed out that the post of tally clerk
in the Port Management Board having similar educational qualification and similar nature of duties as that of a tax collector of PBMC, drawing higher scale, so and so. The proceeding of the meeting dated 5th August 2013 was confirmed at a meeting held on 20th August 2014. This would appear from annexure so and so. At the meeting dated so and so, one agenda was in enhancement of scale of pay of tax collector. The majority of the council resolved to upgrade the scale of pay of so and so with immediate effect. This was the issue, my lord. And thereafter, next page it says, the petitioner says that pursuant to such resolution by order dated so and so, the office of the municipal council revised the pay scale of certain category of post under the revenue section of the council, including the post of tax collector in line with the resolution dated so and so. The petitioner enjoyed the higher scale of pay for about 2 years till the end of December 2017 by order dated 29 December 2017 issued by the Secretary PBMC. The enhancement of pay scale of the petitioner was withdrawn. The ground for such withdrawal as mentioned in the order was that the revised scale of pay was not notified by the Andaman Nicobar administration, amending the existing recruitment rule with the approval of the administration. And as such, the enhancement has been considered to be irregular by the administration. The order dated so and so is under challenge. Now, my lord, kindly come to page number 8, my lord. After the stand taken by both the parties, my lord. Second paragraph. The court says, I have given my anxious consideration to the rival contentions of the parties. The impugned order dated 29 December 2017 withdrawing the benefit of higher pay scale that had been granted to the petitioners recorded that the said order was being passed because the grant of revised scale so and so has been considered to be irregular by the administration because the same has never been notified in the official gazette. Firstly, no decision of the administration has been placed on record to the effect that the enhancement of the pay scale of the tax collector was irregular on the ground of not being notified in the official gazette. Secondly, no requirement in law has been pointed out by the respondent that such enhancement must be notified in official gazette before the same can be taken effect. Thirdly, the petitioner and indeed the other beneficiary of the enhancement of the pay scale had or have no control over the enhancement of pay scale being notified in the official gazette. The respondent had consciously conferred the benefit on the petitioner, realizing that the petitioner deserves such benefits. The respondent cannot put at naught such benefit by their own failure to notify the enhancement of pay scale in the official gazette. Even assuming that in law the same was necessary to give effect to the enhancement of the pay scale, it is titled that one cannot take advantage of his own wrong. The submission made on behalf of the respondent that any resolution of the municipal council will have to be vetted by the competent authority in the administration for the same to become effective is not acceptable to me. Regulation 197 and 198 of 1994 regulation, as I read them, do not say so. The said regulation merely confer a supervisory power on the administration to ensure that the municipal council or any other authority under his control carry on their duties within the four corners of law. Any and every resolution or decision of the municipal council is not required to be approved by the administration for the same to become effective. After all, the municipal council is an autonomous body and its function would be highly inconvenient and jeopardy if each and every decision of the municipal council requires to be mandatorily approved by the administrator. Regulation 205 of the 1994 regulation, I am not reading, my lord, I have relied upon it. The impugned order says that the revision of pay scale and other has been considered to be irregular by the administrator. Apart from the fact that there is nothing on record to show that the administration has held so, merely on the ground of any irregularity not affecting the merit of the case, no act done or proceeding taken by the municipality can be questioned. I am of the view that even if non-notification of the relevant resolution for enhancement of the pay scale in the official gazette is considered to be irregular, the same does not affect the merit of the decision, and on the ground of non-notification per se, the resolution cannot be undone and withdrawn. A substantial benefit conferred on the petitioner by the respondents after due deliberation cannot be taken away on such a flimsy ground. A learned advocate for the municipal council urged that the tax collector and so and so cannot rely to be the equal pay equal one claim. The submission cannot be accepted at the municipal council meeting held on 5th August 2013. It was recorded that the post of tally clerk in the PMB and the post of tax collector in the municipal requires similar education qualification and involves similar nature of duties. Hence, it does not lie in the mouth of the municipal council to now contend that the tally clerk in the employment so and so are not similar. If they are,
Not relevant.
this
because
is not
the only
relevant.
issue is
Irregularity.
no approval.
No approval. And the court
It
said
was not extended.
not extended. Court say it is your wrong. You have not taken regularized it. For that, why should we suffer? This is what the court held.
That's all.
Yes.
Reserved.
One more thing, my lord, I would also like to place one judgment and more fully, my lord, this judgment with Learned Sir's place is under challenge, my lord, before this bench only.
Maybe 2021 judgment they challenge this month, my lord. This month when I filed a writ petition for compliance.
Reminded them to challenge actually.
Yes, my lord. Yes, absolutely, my lord. Absolutely. I have reminded them to challenge.
With filing of the writ petition, they have woke up from slumber and they challenge.
Yes.
Not that.
Yes, what is your relevant?
At page number 44, editorial paragraph 61 and 62, my lord. My 61, I am reading page number 40. My page number, your lordship will find from the top of the page.
Yes,
Top
page
left
number?
hand side. 44, my lord.
It starts with page 762.
No, my lord, from there, here your lordship will find the page. Top left hand side.
No, right.
Under the SCC only.
44.
44, my lord.
Yes.
Well, paragraph number 61 in Pollock and Mulla's seminal testatrix on the Contract Act, it has been noted that section 65 does not operate in derogation of the maxim in peri delictio potio es condentio possidentis. Section 65 is not in derogation of the common law maxim ex dolo malo non oritor actio and in peri delictio potio esio condenti possidentis, and only those cases as are not covered by this maxim can attract application of the provision of section 65 on the footing that when an agreement in its inception was not void and it was not hit by the maxims but is discovered to be void subsequently, right to restitution of the advantage received under such agreement is secured on equitable consideration. The section has been held not to apply where both parties knew of the illegality at the time the agreement was made and were in peri delictio.
Applicable.
I'm reading paragraph 62 as well, my lord. Thus, the application of section 65 of the Contract Act 1872 has to be limited to those cases where the party claiming restitution itself was not in peri delictio. Now, paragraph 62, my lord. In the principles of law of restitution, it has been noted that all claims for restitution are subject to a defense of illegality. The genesis of this defense is in the legal maxim ex turpi causa non oritur actio. No action can arise from a bad cause. A court will not assist those who aim to perpetuate illegality. This rule was initially recognized by the House of Lords in the decision in Holman versus Johnson. Lord Mansfield held that the objection that a contract is immoral or illegal as between the plaintiff and defendant sounds at all times very ill in the mouth of the defendant. It is not for his sake, however, that the objection is ever allowed, but it is to found in general principle of policy which the defendant has the advantage of, contrary to the real justice as between him and the plaintiff by accident, if I may say so. The principle of public policy is thus ex dolo malo non oritus actio. No court will lend its aid to a man who found his cause of action upon an immoral illegal act if the forum if from the plaintiff's own stating or otherwise the cause of action appears to arise ex turpi causa or transgression of a positive law of this country, there the court says he has no right to be assisted. So now here both the petitioner and defendant, I don't know whether the defendant, both the petitioner are well aware that this
So, this thing has to be placed before the chief administration and all.
Aware of the rules of yours?
The mistake of law cannot be ignored, my lord. These are rules, my lord.
And he
So they are
speaks of illegality, not irregularity. You have no claim of illegality in your case.
No, this is very irregularity as well, my lord.
Anyway,
So these are my submissions, my lord. Get.
there is no illegality at all. That is not your claim. You only claimed it to be irregular.
Irregular.
Because approval was not.
I remember that judgment relied by my learned senior is also under challenge. So, my lord, now rests
Not
upon your
state.
lordship, not state, but.
No, my lord, even section 5 is not admitted. Appeal is not admitted.
But when justice, but our judgment is there that when an order is under challenge, it loses its finality, my lord. That there are judgment.
No.
But our judgment is.
No, that's right.
State.
No.
Even the appeal is not.
Even the preclusion challenge loses the finality.
Mere challenge doesn't deprive a judgment of its finality.
No, that's
Not
not
in law.
that is it. He can execute
Anyway,
and all.
You have made your efforts. Arguments concluded, judgment reserved. Please send it inside. Next.
Appeal.
Item 21, WP 36 of 2018.
I am appearing for the respondent, my lord.
But I am for the, I'm taking not today or because Mr. Chakravarti is not there.
Is it a short matter?
My lord, an award was passed by the Labour Court in the year 2018. They have challenged it. Since then, it is pending, my lord. I am out of service.
Because if I can keep it on Wednesday when Mr. Chakravarti is coming, but
My lord.
Thursday is our last working day.
Then let it be the next, sir. Practically, it is not possible, my lord.
No, day, I don't think so. By consent of the parties, let the matter appear under the,
Let them on their prayer, my lord, because I am ready, I am available. my lord.
on prayer of the respondents, the matter be placed before the next available settlement.
WP 116 of 2019 with WP 133.
But this matter is also our appeal only.
I am appearing for the respondents, my lord.
Same order,
Same order, my lord.
same order.
Item 24, WP 179 of 2019.
Petitioner, yes, where is he? Next circuit. On prayer of the petitioners, the matter be placed before the petitioner, the matter be placed before the next available circuit bench.
Item 25, WP 206 of 2019.
25, I am appearing for the petition, my lord. My learned friend is not there. Let it be in the next circuit, my lord.
Who is appearing?
Mr. Kamraj, my lord, he is not.
None appears for the respondents. Paragraph, the matter be placed before the next available circuit bench.
Item 26, WP 219 of 2019.
Okay.
Yes. Mr. Chakravarti is appearing. Short matter, you can complete on Wednesday. He's asking, yes. On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 18th.
Item 27, WP 241 of 2019.
This is our appeal, my lord.
I am appearing for the respondent.
You can finish in a day. No. On prayer of the petitioner, the matter be placed before the next available circuit bench.
Item 28, WP 246 of
My lord,
2019.
28 and 29, my lord, I am appearing for the petitioner. My land was acquired without any process. And already in terms of the order of my lord Justice Basag, my lord, an inquiry was conducted. Tahsildar has submitted his report. Now, my lord, apart from that, the executive engineer has submitted a
report to the Tahsildar. I have a copy which was served upon me, my lord. I am just placing it. Along with this, my lord, there are documents. Those documents were not supplied to me, nor the executive engineer who is the respondent herein. He has filed any affidavit before this honorable court.
Affidavit was called.
Yes, my lord. They have only filed the affidavit of
The survey.
the Tahsildar, my lord. Respondent number 7.
There was a subsequent survey after the writ petition, during pendency of the writ petition.
Yes, my lord.
That report is on record.
That report they have filed, my lord. Now, my lord, along with this, my lord, they have served a copy. The executive engineer who is a party here, he has served a report to me which speaks about certain documents, but no such document was supplied to me along with this, nor the authorities, apart from respondent number 7, has filed any affidavit before this honorable court.
You are referring to the notification.
One letter, my lord, of 17th March 2022.
Yes, 17th March refers to a notification.
My lord.
You have not been given a copy of that notification.
No,
you said.
and my lord, one more letter is there whereby they say that there are I'm sorry, my lord. This is that letter, my lord. I'm sorry, my lord. This is written by the chief engineer to the executive engineer to the chief engineer, my lord.
Documentary evidence, these documents.
In this, certain documents were discussed. Those were not supplied to me, though this letter was communicated to me. It says, with respect to the above said matter, Tahsildar South London has already completed survey of the area and submitted a detailed report to the London government pleader, a copy of which has been shared to this office. During examination of report, it was observed that draft affidavit, survey report point, mention no documentary evidence regarding acquisition of land of pipeline is available as per the revenue record. However, as per the Andaman Nicobar Gazette notification, plot number so and so has been acquired for the purpose of laying pipe during so and so. None of the parties have ever objected laying the pipelines. Hence, Tahsildar Southern has been informed accordingly by dated so and so. Copy is enclosed for ready reference. Further, as per the letter Honorable High Court, in the above said matter, following document has to be submitted to this Honorable Court. Documentary evidence in support of land, detail of fresh survey for laying of water pipeline. Accordingly, a copy as well as survey map showing detail of road, existing pipelines routes, as well as proposed future pipeline route along existing road is enclosed here with the request. This document was never supplied to me, though this letter was supplied to me, nor they filed it in any affidavit, nor that found part of the any affidavit filed before this honorable court. Now, my lord, the issue is that they have taken my land without acquiring the same. When the Tahsildar conducted the report, the Tahsildar said it's correct that at no point of time the said land was acquired. Now, my lord, the question is the pipeline which is going or passing through my land, whether it can be shifted to some other place or not. Now, my lord, they say yes, it can be done. In the last paragraph, detail of road, existing pipeline route, as well as proposed future pipeline. Got it, my lord, in the last paragraph. So, my lord, if they submit that report, according to that, they have to act. When there is a proposal, future pipeline route along with existing road is enclosed. So, they can definitely shift it from my land. And for that, they have submitted a plan that was not supplied to me.
The report is also not on record.
And my lord, it is pending since 2019, my lord.
And this order has not been complied with. Justice Boshak served.
They have
December
conducted the
15,
inquiry.
2021 order. But there is nothing further on record.
Yes. It is not there, my lord. No, my lord, they have to file a report, my lord.
But affidavits have been filed, I find.
Affidavits are filed by seven also and as well as,
No, there is a survey report. There is a survey.
Survey report, but that that letter which I have shown and they say, my lord, the survey map showing detail, that survey map is not part of the set. That they have not filed deliberately, my lord, because it shows an existing road proposed is there whereby they can shift it from my land.
Will you file copies of those documents before the court? Have you seen the 22nd March letter? You've referred to certain documents.
I could not also find from my report, so I will check it up with the department. I'll file this letter and this map.
These details are to be filed, my lord.
I'll file the details along with that.
Learned counsel for the petitioner submits that the petitioner has been served with a copy of a letter issued on 22nd March 2022 by the Executive Engineer, Public Health Engineering Division to the Chief Engineer, APWD, Port Blair. The letter refers to certain documents which have neither been made over to the petitioner, nor submitted before the court. Paragraph, learned counsel for the respondents seeks to submit the said documents in court. Paragraph, the matter be placed before the next available circuit bench.
That's no way of affidavit.
By way of an affidavit. Huh? Next.
Item 30, SSC 5 of 2021.
Who is appearing for the paper books are ready?
Yeah, paper books are ready. I have already filed it.
Who is appearing for the respondent?
Your Lordship, Mr. Tabrez appears, Your Lordship. It's a ready matter, very old-aged person, Your Lordship. The petitioner is more than 80 years.
I do not find the respondent.
But appears what it appears that he is for his wife's treatment has gone to main.
The only difficulty is that, Your Lordship, I've been waiting for this disposal of it, but it comes very down in the list, so the chances of getting it heard was very less. And now when it has come, Your Lordship, the other side is not there. It's a very difficult thing.
And it's a medical ground, so I don't think we should.
Let it be posted tomorrow. Let me take next some chance.
How Thursday is the last working day. How can a second appeal be heard?
Very short point.
In 2 days.
Non-payment of rent. That is the only point.
But since he is in the mainland, he's not come back. Let it appear for the next ticket. Since learned counsel for the respondent is not available, let the matter be placed before the next available circuit bench.
Item 32, WPA 97 of 2020.
Yes, Mr. Venukumar is there.
My lord, this matter, let it appear tomorrow, my lord, because I am not going to do this matter, because 3 matter which I mentioned, my lord, this 4 matter always, I just want to tag this all 4 matter, otherwise in between, my lord, circuit is over.
Not today?
Not today, my lord.
Mr. Chakraborty is appearing.
Yes, Mr. Chakraborty is appearing.
Item 33, WPA 8263 of 2020.
My lord, I am appearing for the petitioner in this matter.
Yes. Where is Mr. Shivpal? Affidavit and reply is yet to be filed. Mr.
Filed,
Kumar,
my lord. On the last day, after the order of this court, I have filed, my lord, before the registry. My lord.
but where is Mr. Shivbala? No. None appears for the respondents. Yes,
Just not today, my lord.
short matter. Short matter,
Can be, my lord, can be taken. Can be taken, my lord.
not today.
Item 34, WPS 44 of 2020.
My lord, Mr. Rajinder Singh is appearing, is not well, my lord. I requested me to seek for a day's accommodation.
My affidavits are complete. I have been served with the affidavit of
Reply.
reply, my lord. We have filed them opposition. So this can be fixed for hearing, but can go to next circuit or as per your lordship. So whatever, this is, I don't think this will be a very long matter.
Shall I make it not today only?
Let it be not today, my lord. He requested me.
Item 35, SAP 5 of 2022.
Affidavit service was not found on that day. It is found closed. Section 5 hearing is there.
Who is appearing?
None appeared in spite of service.
Where is the affidavit of service? Oh, it's a refusal.
Affidavit, but is refused.
So that is good service.
Yes.
Yes, this is a
115 days delay in filing of the appeal. And during that period, the Honorable Supreme Court also excluded that period from 15 March 2022, 28 April, 28 February 2022. In spite of
can
that,
is allowed.
in spite of, yes.
Can is allowed. It's fine.
Para 12, 13 and 14, I have explained the 14. 13, 12, 13, 14.
Can 1 of 2022. Affidavit of service filed by the applicant slash appellant indicates that notice served upon the respondent was refused. Such refusal amounts to good service. Paragraph. The applicant slash appellant seeks condonation of delay of 115 days, 115 days in 115 days, 115 days in preferring the appeal. Paragraph, the explanation placed by the applicant is found to be explanation placed by the applicant for the said delay is found to be satisfactory. Paragraph, in view of the above, comma, can 1 of 2022 is allowed. Paragraph, the delay in filing the delay in preferring the appeal is condoned. Paragraph, the matter be placed before the Honorable Division Bench
Division bench for admission. Grateful.
for consideration of admission. For consideration of admission. Next.
Petition, my lord, it will take some time, my lord, so let it be in the next session.
By consent. By consent of the parties, the matter be placed before the next available circuit bench.
Lordship, in this matter, I am from the petitioner. Let it be placed before the next hearing.
On prayer of the petitioner, the matter be placed before the next available circuit bench.
Obliged, Lordship.
Item 38, WPA 90 of 2022. Item 38.
No one.
But I am for the.
Petitioner? None appears. Yes, but is she there? None appears for the petitioner. No accommodation is sought. Paragraph, the matter be placed before the next available circuit bench.
Item 39, WPA 91 of 2022.
I am for the petitioner. This may be also posted in next hearing.
On prayer of the petitioner, the matter be placed before the next available circuit bench. Give your name.
Item 40, WPA Lord, I am appearing for the respondent, my lord.
Who is appearing for,
Lord, Mr.
who is appearing for the respondent?
Vidur Narayan.
Petitioner?
Vidur Narayan was there, ma'am.
None appears for the petitioner. No accommodation is sought. Paragraph, the matter be placed before the next available circuit bench.
Item 41, WPA 97 of 2023, which WPA 51 of 2023. What I am saying for next.
I am for the respondent, my lord.
Petitioner?
They are appealing for the petition. They are the petitioner.
Next, sir. On prayer of the petitioner, the matter be placed before the next available circuit bench. What has happened? Dasara mood has set in. Next.
Item 43, WPA 114 of 2022.
I am appearing for the petitioner, my lord. Let it be in the next session.
By consent of the parties, the matter be placed before the next available circuit bench.
Item 44, WPA 133 of 2022.
Same prayer, my lord.
Same order.
Item 45, WPA 1.
There was a direction to file affidavit in opposition by me, my lord. I've been informed the affidavit in opposition is filed, my lord. I have also a copy, but I'm not served upon him. So, my lord, I'll serve with affidavit in opposition, my lord.
Who is appearing?
He's for the petition.
I don't know what stand they are taking.
You've not received a copy?
Copy has not been submitted. So there be a direct.
The affidavit is on record. You need to come back with a reply. Learned counsel for the petitioner submits that copy of the affidavit in opposition has not been made over to him. Learned counsel seeks to use an affidavit in reply. Paragraph, the matter be placed before the next available circuit bench.
I'll serve them, Lord. I'll serve them by course of today or if.
In course of this week.
With tomorrow I'll show you.
I am appearing for the petitioner. Here, my lord, I am praying for hearing of this matter, madam, either today or tomorrow, because
Tomorrow, my lord, hearing in this matter for me is not possible. My lord. This is a long matter.
No, it's a very short matter. A statutory settlement was arrived between the parties. They did not adhere to the said settlement. I approached this writ court. Writ court passed an order saying that this statutory settlement is binding upon you and directed to pass necessary orders, my lord. After the order of the writ court, once again they rejected my claim, my lord, despite of that. Statutory settlement is binding. It was never challenged before any court of law by them. And there is an order of the writ court Despite of the order of the writ court, they have passed an order on 2nd June 2022.
But day after.
Tomorrow I may start, my lord.
Tomorrow we can start. Then.
I will not make much submission because there is a statutory settlement. There is an order of the writ court.
Let it appear day after tomorrow,
My lord.
because if we can complete in a week, cannot complete in a day, I cannot take it up.
My lord.
Because Thursday, this is the difficulty. We have one working day less this time, actually.
My lord.
On prayer of the respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 18th.
My lord.
Item 47, WPA 175.
I could get back the envelope addressed to the private respondent as an insufficient address. To again, it needs to be, let it come in the next.
Since service upon the private respondent is not complete, comma, the matter be placed before the next available certificate.
Item 48, WP 179 of 2022.
My lord, 48, 49, 50, this all will take some time, my lord. So let it be in the next circuit.
Who is appearing for the respondents?
Mr. Chakravarti. only.
No, he is also not there.
Yes.
By consent,
My lord, by consent, let it be.
by consent of the parties, the matter be placed before the next available circuit bench. 48, 49 and 50.
50s. There are different matter, but same order may be passed.
Item 51, WPA 468 of 2022.
None appears for the parties. The matter be placed before the next available circuit bench.
Item 52, WPA 685 of 2022.
I am appearing for the petitioner, my lord.
Here also, Mr. Chakravarti.
Chakravarti is there.
Where is his representative gone?
He went to that code. So let it be next circuit by on their ground, my lord. I am not seeking time in this matter.
None appears for the respondents. Paragraph, the matter be placed before the next available circuit bench.
Item 53, WPA 862 of 2022 with 938 of 2022.
My lord, I am appearing for the petitioner in 53 and respondent in 53.
Mr. Lam is a.
Tulsi Law is appearing for the 53 as an respondent, not the 54 as an petitioner.
Yes. Where is he?
It's for hearing, just not an applicant. Let it be day after tomorrow.
Hearing cannot be taken up day after
It is
tomorrow,
nothing.
not possible.
It is against an award passed by in labor code.
How can hearing and order be passed in a day?
On their ground, let it be adjourned.
On prayer of the respondents, the matter is adjourned. Paragraph, the matters be placed before the next available circuit bench.
Blair. Item 55, WPA 59 of 2023.
My lord, I am appearing for the petitioner. Here I am pressing for the hearing, my lord, because
Who is appearing?
Mr. Chakravarti is appearing, my lord. It's a very short matter. My lord, these drivers, the union raised a conciliation before the conciliation officer. Conciliation officer, after giving opportunity to both the side, arrived to the finding that it cannot be amicably settled, and as such he referred the matter. He submitted a failure report under section 12 subclause 4 of the Industrial Dispute Act before the appropriate government. Appropriate government, without assigning any reason, refused to refer the matter, because my lord knows the scope under section 12 subclause 5 is an administrative power, nothing more than that.
Very limited. No?
Very limited. They rejected, my lord. I challenged it before the writ court set aside the order and said that either you pass a reasoned order or it will be deemed that it is referred. Immediately thereafter, they passed an order whereby they said that it cannot be referred. You are a contract employee, this and that. Again, touching the merit of the case. This is one part. Another part is that, my lord, for the similar set of same workers, same employees, same union, challenge, and in this matter, they are seeking for 1/30th. There they were seeking some overtime allowances and all. That has been referred. How it can be? If I am a workman under section 2, as I am a workman. If I am not, I am not.
That was also in case of contractual work.
Same persons, same persons, my
Not
lord.
today.
Yes, my lord.
Please inform the other.
Yes,
side.
yes, my lord.
Not today.
Item 56, WPA 460 of 2023.
Item number 56, my lord, short passer of the units.
Yes,
She is in court number 2, my lord. I see you. Yes, Angelina.
who is appearing to the respondents?
Shatadri Shan, check. Shatadri Shan, sorry.
No,
is appearing. They're also in court number 2, my lord. So short passer of the
Please come.
But this matter will take time for hearing, because there's the excise matter and all, my lord. Ms. Nag is also on his,
Yes, my lord.
on her legs before bench too, my
On your prayer,
lord.
on prayer of the respondents, the matter be placed before the next
My
available.
lord, my
settlement.
seniors want to do this matter, my lord. Just short passer may be given, my lord.
If it takes time, cannot be considered.
It will take time, my lord, because there are this things are there, my lord.
Chakravarti is not there also. today. Next,
Item 57, WPA 479 of 2023.
57, my lord, your lordship had heard in some detail the matter with regard to the quarries. Your lordship had wanted to know about the minor mineral rules,
Yes.
whether there is any provision. There is a provision not for appeal, but for revision. But equally, there are a number of judgments and propositions which will indicate that the writ jurisdiction will
like,
lie. The
that
thing
is
is
under
that,
exceptional circumstances.
no, not an exception. My lord will find I've got everything ready. Once Mr. Chakravarti comes, the matter can be heard out.
How can all these matters be heard only on Wednesday? Thursday is the last work.
But I understand. I am ready today, my lord.
And all this matter will only will include this short point, whether there be appeal or revision or.
The short point which
On
the
the
state
other-
never thought of all this time. So today it is not his discussion to make it a short point. I have to argue the matter.
He has to argue the matter.
I can fix it on Wednesday, no difficulty, but then practically will it be possible? Let it
Then
appear
let
on
it go-
Wednesday,
Let
yes,
it, let it go to the next circuit then if your lordship so chooses,
by consent.
by consent.
By consent of the parties, the matter is placed before the next available circuit bench. One day short means a lot actually. Can't help.
And this circuit, I've had bad luck, so I have not been able to get a single matter heard out. Deep privilege. मेरा एक भी नहीं हुआ सच में.
Item 58, WPA 485 of 2023.
Mr. Binu
My
Kumar
lord,
is
Vinod
appearing.
is like before the court number 2. Saying for not to.
Yes, not today.
Item 59, WPA 487 of 2023.
Item number 15, my lord. My seniors asked me to pass over, my lord. They want to do this matter, my lord. So urgent matter.
Respondents. Who is appearing for the respondents? No one. Have you served?
Yes, my lord. Sir, my lord.
Very well passed over. This-
Oblige, my lord.
Item 60, WPA 583 of 2023.
Lordship, Miss A. Zinu is appearing for the respondent number 2 and 3 in this matter.
This can has to be taken up in next second, worship. The effect of SUVRA Act and the division bench order has been completely overlooked and certain orders were passed by the bench.
So it will be a little
Time,
extended.
yes, yes, very time.
Obliged.
By consent,
Yes, no. Or at my instance, because they are appearing for the bank for many reasons.
The-
worship.
I know,
At
yes,
my
yes.
instance.
on prayer of the petitioner, the matter be placed before the next available circuit bench.
Item 61, WPA 625 of 2023. Mr. Binu Kumar is being and we are only waiting to.
Yes.
Not today. Not today, ma'am.
Not this week,
Not today, ma'am.
not today. We will come back tomorrow, let us. Not
Alright.
today.
Item 62, WPA 643 of 2023 with.
Maybe taken up tomorrow morning. 60. Short matter.
Not today.
Otherwise.
Item 64, WPA 665 of 2023.
And therefore the petitioner there to file the opposition.
We have filed our approach. Not so copy. I will serve a copy.
Let me see if it is,
Let lordship.
Then in terms of the, we are not a amusement planning. Time will come.
opposition file. Yes, opposition is fine.
Yes, I'm not being given, I'll take the copy from you.
So you want to contact the reply?
Yes, yes. Time may kindly be
Learned counsel for the petitioner seeks to use An affidavit in reply to the affidavit in opposition filed by the respondents. Paragraph, the matter be placed with the next available circuit.
Madam, stop the copy, madam.
I have not recorded anything. Shall we call the passed over matter? But the respondent is not there, bad luck.
Your Lordship, this particular person's business is, means he is unable to work, Your Lordship. The reason is that the authorities have, what imagination they have got, I don't know. And what is the basis also, we don't know, that some allegation is upon this particular petitioner that he is involved in certain illegal activities. So he has been restrained from entering into the airport. And his job itself is in the airport. So for these many years, if you have anything, you
call 59. Yes, respondents, Mr. Lal is appearing. Yes.
Not today,
Not today.
let this be specifically fixed, Your Lordship, so that it can be disposed of.
He wanted to come back with a supplementary affidavit in opposition. Please inform him.
Because, Your Lordship, what he did, he has,
It is supplementary affidavit.
that has already been filed. And practically the documents which have been enclosed along with the supplementary affidavit, that is
Affidavit in opposition.
that is in my favor.
Supplementary. Not today.
Yes.
Item 65, W679 of 2023.
But I am for the respondent in this matter. The petitioner usually appears through PC. You can meet your.
Anyone appearing through VC? No? None appears for the petitioner, no accommodation is sought. The matter be placed before the next available circuit bench.
Item 66, WPS 684 of 2023.
You are appearing for the respondents?
Respondent, madam, we have filed our affidavit in opposition.
None appears for the petitioners, no accommodation is sought. The matter be placed before the next available circuit bench.
Item 67, WPS 691 of 2023.
Yeah, I'm appearing for the petitioner in the item number 68.
67.
67 and 68.
Waiting for 67.
Well, here, there was a direction to file the report by the municipal because the construction work is going on, illegal construction work.
Mr. Shivapalan is appearing. Where is he?
No, Millard,
For the respondents.
for the respondent, Mr. Chakravarti is appearing.
Mr. Chakravarti.
My lord.
Yes.
The private
You are the
respondent has filed
respondent in this matter.
in
the first matter.
First
Yes.
matter. But in the second matter, I filed the CAN application. My lord.
Petitioner,
Venu sir is appearing for the petitioner, my lord, in 67 item number. He is like before the court number.
And 68, I am appearing, my lord. In the 67, I am for the private respondent, and in 68, I am for the petitioner. My lord.
But I am from the.
There is a direction to file the affidavit, though the private respondent has given with the affidavit, my lord. The
Now there is a direction to file a report, my lord. I am filing my report, my lord.
so let me come tomorrow, my lord, because they are saying the work is not going on. But the illegal construction is still going on, my lord.
And there is a stay order from PVMC.
Yes, my lord. There is a stay order. In spite of stay order, my lord, they are working it.
an affidavit of in opposition was called for.
My lord, that has been filed, my lord, by the.
That has been filed by Mr. Dinu Kumar, sir, my lord. He is for the private respondent in one matter he is for the petitioner. My lord.
My lord.
Yes.
In my matter, my lord, there was a direction to file the report by the municipal authority. So I have received the copy, my lord. Let me come tomorrow, my lord. Because there is a stay order from the municipal authority. In spite of that, they are working, my lord. For that reason only, I filed this CAN application, my lord, along with my writ petition. At the time of filing of the writ petition, it was not there. The work was not going on. So I couldn't file the stay application, my lord. But thereafter, recently, again, they have started, my lord.
The report says that there is no construction going on. The penultimate paragraph.
I'll come back tomorrow, madam.
Tomorrow.
I just received the copy, my lord. I'll come back.
The site inspection report submitted by the building inspector is taken on record. Paragraph, learned counsel for the petitioner in WPA 668 of 2023. Seeks to peruse the report. Paragraph, let the matter appear under the same heading tomorrow, comma, that is on 17th.
Obliged.
Item 69, WPS 694 of 2023.
Maybe taken up tomorrow, maybe.
How many matters can you take tomorrow? I don't know. Not today. Very well.
Item 70, WPS 698 of 2023.
My lord, I'm appearing for the petitioner, my lord.
Yes.
In this matter, fix on to tomorrow.
Again tomorrow,
Yes.
not today. But tomorrow there will be no tomorrow. Please keep that in mind. Next.
Item 71, WPS 699 of 2023.
Next circuit, they have not filed opposition, they have not sought time.
Who is appearing?
I have filed an opposition, but I'll use my reply.
I'm giving you my copy.
Yes, the file.
I'll use the reply.
Learned counsel for the petitioner seeks to use an affidavit in reply to the affidavit in opposition filed by the respondents. Paragraph, the matter be placed before the next available circuit bench.
Item 72, WPS 727 of 2023. And this matter I am for the
Petitioner,
this matter actually was appearing. But this is, you have filed our opposition and all.
Ms. Padeshia Munda was appearing for the petition.
He is appearing and Mr. Meet was appearing virtually from Calcutta. So what has happened in that this is regarding tsunami compensation matter. So some compensation amount was given and some is pending. We have written to ministry. So this is pending.
Not today. It's a short matter. Will you inform me?
But we have informed, we have given in affidavit, whatever we have done in this.
No, please inform learned counsel so that we can take up the matter tomorrow.
Okay.
Not today.
Item 73,
Your lordship, I am for the petition, very short point. The petitioners,
Respondents?
yes, they are
I
appearing.
am for the respondent.
The petitioner became eligible to get the benefits of MSCP scheme in 2021, May 2021. Now, they have started the process.
Affidavits were called for.
He is already completed. I have filed the reply, also given the copy also to the side.
Where is the reply?
It will be there in the registry the file. यहाँ तो file नहीं कर सकते ना, registry में.
Let it be not today, I'll go through it.
Very short point. On that particular date, there was no case against the petitioner. The point is that a case which has been initiated only in 2023, can it affect the right of an individual whose right accrued 2 years before that? He is entitled to get the MSCP scheme in May 2021. So if they have initiated the process lately, does it mean, your lordship, that they can take into consideration the recent case which has been initiated against the applicant? This is the point. Absolutely a point of law, your lordship.
You want to come back tomorrow?
Tomorrow, if a very short matter, then it can be fixed.
Let us try. Let us give it a
Let
try.
us try on tomorrow.
Yes, not today.
Like, as it has been little bit heard, your lordship, if it is advanced, we can finish it off.
Tomorrow, I don't think like a lot of matters have been shifted to the next circuit. So let us see.
You know.
Item 74, WPA 838 of 2023.
Yes, no one.
But no one is appearing in this matter.
None appears for the parties. The matter will be placed before the next available circuit bench.
Item 75, WPA 841 of 2023.
76.
75 to 78 actually
Hmm.
are more of the similar identical type
Yes.
of matters, my lord. And this matter requires a at length hearing, my lord, because this is regarding a policy and a scheme, my lord.
Your lordship, may I say, your lordship, it is really not required that much hearing because they have to show that in terms of the rules, they have taken a decision. That they have to show. If there is a rule, of course, your lordship, I'm out of the court. If there is no rule, then you can't do.
Fine.
Fine, fine.
Please give me the file.
But my lord, this Mr. Chakraborty has to do this matter because there
What they have done, your lordship, they have taken a decision that only local people will be allowed to purchase auto. No other person can purchase the auto. That type of decisions they have taken. The person,
That should be on the basis of some rule.
that's what I, your lordship, if they're able to show any rule, I'm out of the court.
You filed a reply to the affidavit?
Your lordship,
Yes, yeah, that's complete.
complete.
So when will you come back?
by Wednesday, my lord.
Wednesday.
This in absence of Mr. Chakraborty, my lord, I can't do this matter, my lord.
Next
Let us-
circuit.
Let us take a try, your lordship, on Wednesday.
Wednesday, several matters are there where Mr. Chakraborty is appearing. If you still want me to fix it on Wednesday, I can do that, but then it will.
Let it be the list, your lordship. If any chance is there, otherwise.
Very. On prayer of the respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 18th.
Yeah, sure. Okay.
'75 to '78, same order. All of them.
Only in 76 and 77.
So the same order we passed.
Same order, my lord, because the scheme is being challenged. The
Scheme is challenged.
Who is appearing? in
Mr.
78?
Tapan Das is there in 75 and 78, my lord.
Yes. Rajendra Singh, Mr. Rajendra Singh.
Rajendra
Let the
Singh
same
and-
order be passed.
Yeah.
Item 79, WPA 848 of 2023. Lord, it can be disposed of because, my lord, this is under the Gratuity Act. The employee who has worked under the bank of the Punjab National Bank he has resigned from the service. The gratuity has been not paid. He went to the tribunal under the Gratuity Act.
Yes.
The tribunal has passed an order. And after 1.5 years, when they not complied it, he went to the Deputy Commissioner for execution. Deputy Commissioner issues the certificate for execution. They come with the writ petition. Not the act says it should be an appeal. And they have to deposit an amount to the
Yes.
appeal authority. They brought a certificate. So not this is pending for court line. Through an
Who
state
is
legal
appearing
service.
for the- You are the.
I'm for the respondent number
respondent.
2, my lord.
What about the petitioner?
Lord, he's pending quite long. Because I served the copy because I raised the point of
Ms.
mendability.
Ponna Roy Choudhury is appearing. I think she appears virtually, I think, because
Let
that's
it be
written
not
here.
today, let's see, my lord, tomorrow anybody is coming, because this is the only point that has to be decided. And I appear as through state legal service authority.
And there was a direction for opposition.
I filed it,
You
my lord. I
filed?
served advance copy to them. Long way,
It's not on record. Please find it.
long back it has been served.
I'll just make it not today.
Yes, my lord. Oh, check that. What very opposition.
You've served a copy of the
Yes,
opposition?
I served. I have an endorsement of the council. Mr. Alakes Sarkar.
Please try and inform her,
Yes,
then
yes.
we can hear the matter tomorrow. Next,
Right. Item 80, WPA 850 of 2023.
Item 80 to 83 are for filing affidavit in opposition, but I am seeking one extension, first extension, madam.
Interim order
That time, there is an interim order.
I'll just take one of the files. In all the four matters.
All similar matter.
Similar matters.
Similar matter.
Learned counsel for the respondents seeks extension of time to file the affidavit in opposition. Paragraph affidavit in opposition, we file within 2 weeks.
2 weeks, madam.
Within 2 weeks from date. Stop affidavit in reply, comma, if any comma, be filed within a week thereafter. Paragraph, the matter will be placed before the next available circuit bench upon completion of, upon exchange of affidavits. Paragraph, the interim order granted earlier is extended till 20th December or until further orders, comma, whichever is earlier.
In all the matters.
Same order in all the four matters.